keeps me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
Hey, hey, hey. Welcome back, everybody. Good to see you. Good to see you. So, we're getting ready for Stephan Sterns' pretrial hearing. He's trying to keep out the evidence from his phone. This is the CSAM trial that we're talking about. It's a pretrial for that. But before we start before we get to that, I really wanted to show you guys what the jurors from Lorie Vallow's trial had to say, because I just think it's interesting whenever jurors are interviewed. So I'm going to play that. Let me share the link. All right. Oops. It's from Idaho News. Here's the link to the video in full so you can watch it without any commentary if you so choose. Here it is. All right. Shout out Nate Eaton. All right. Here we go. Let me play it first. Let me play it for y'all.
Walking out now, knowing, I mean, I think you're knowing how high profile this case was. What's going through your head?
Sadness. It's sad. Whoops, I'm sorry. It's just sad that, this has happened to Charles, and she's given up her life as well. It's sad.
What did you think of her defending herself? Anything that went through the jury's head with that?
Well, for me personally, I thought, what does she have to lose? Guilty or not guilty, what does she have to lose? So,
were any of you folks aware that this woman had already been
I had never been
convicted
heard.
of
I have never
3
heard of her.
homicides?
Yeah, no,
and
I've
the
never
jurors
heard of her
did not
before.
know that.
No, I did not.
And nobody brought it.
And ma'am, would you want to come in and talk too? Do you want to say anything?
Just because there's a lot of backstory here, and this woman had already been convicted of 3 homicides, and they obviously didn't want you folks to know that. Nobody knew that during your deliberations.
No.
Is that correct?
Correct.
Wow.
What was this experience like for you?
It was sad, like as he said. For me, it was the text messages that did it, as far as evidence. And I feel like we uncovered some lies.
Do you
So-
think she?
Knowing now that she was convicted of killing her 2 children in Idaho.
I haven't had a chance to Google everything. I'm sure as soon as we get on the shuttle. So might have more to say later.
Was that difficult going through this and
Yes,
not being
it
able to be
was.
disconnected?
Yeah.
What
It
do you-
just
do you
felt
think
like there was a lot of information that didn't make sense and that was missing.
Do you think she did herself any favors by
No.
defending herself?
No,
You were not impressed with her lawyering skills?
no.
What did you think of her behavior during cross-examination? The way that, and what moments?
All right, I got to pause for some fair use commentary, but let me just say this. I do think that them making it very, very clear that they did not know about Lorie's past is important, because if they had known, and if they had, it could be argued, and it would likely be really good grounds for a retrial, that there was prejudice. And so I'm glad that they did. The court and the state took every opportunity to prevent that from coming out, even though Lorie herself tried to open that door. So I think Rachel, this is after. Rachel says, then how does he know she had nothing to lose? Or is this after? I think he actually meant that nobody, representing yourself, you don't have anything to lose. You're either going to be found guilty or innocent. You know what I mean? That's how I interpreted what he said. But you can, it sort of appears like there was some conversation that was taking place, like prior to the cameras coming on. And so probably they were talking about her prior situation. And then they were asking him, is it okay if we, record you, yada, 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 whatever. And so I think that's what he's referring to. I think it's after also. So I think it could be both. All right, let's keep going. Let me. All right, here we go.
Defending herself?
No,
You were not impressed with her lawyering skills?
no.
What did you think of her behavior during cross-examination? The way that, and what moments she was argumentative with some of the witnesses?
Many days she just was like smiling and laughing and didn't seem to take anything very seriously.
Were you hoping to hear? How much of that did that play into a factor in the decision?
It did.
Were you hoping to hear her testify? Were you hoping to
Yes,
hear
I
all
was. I
witnesses?
was.
And what about you?
I didn't understand why she didn't call any witnesses.
Yeah.
To be honest with you. I don't get
Or
that.
why she didn't have, like, I know she made a statement about the only family that was interviewed was her estranged brother, and why wasn't her parents or her sister, but yet she didn't call them. So,
I mean, in saying that, she is not obligated to prove her innocence.
exactly, yeah.
Except to,
And you gave her that benefit of the doubt. She recognized she didn't have to put on the defense.
she knew.
Right,
yeah,
right.
absolutely, She knew.
Was the fact that she didn't put up a defense or take the stand in her own defense part of your deliberation at all?
Did it
It was
affect
all evidence. It was all evidence that was produced
Yeah.
and presented to us.
Sorry if this was asked, what would you say the biggest piece of evidence for you guys as a jury was when you came to the decision?
Well, for me, like her, it was text.
The
Texts
text
were damning.
history.
What specifically about the text?
Oh, there were so
I don't know
many.
if I can do that. No. Yeah, there was.
I mean,
there
we
was
had
2 of them for me
pages.
that really stood out.
Can
Which
you tell
ones?
us which ones?
The
Um,
Nephi.
Yeah, that was one of them. Soon you will be Nephi, and so will I. So that was one of them, but I don't know if I should say anything more.
We heard so much about dark spirits and religion and how this all plays into it. I mean, as a jury, what's going through your head when you start hearing that in court?
For me, that didn't really play a big role because you have to have evidence of conspiracy, and that is not evidence of conspiracy to me.
Was it
possessed.
unusual for you guys to? I mean, you're talking about her brother Alex, the guy who actually did that was the triggerman. So many players were referenced in this trial, and you never saw them, and never heard from them. That had to be confusing when you guys got back in the jury room. Yeah.
Yeah, it was very confusing.
What did
it just felt like there was so much of the story that was missing.
Did she have any valid arguments?
Blessed Nate over there saying, did you have any valid arguments? No. Hey, Allie, what you doing, babe? How's it going?
Hey, pretty good. Just happy to be here with you to watch this hearing. And yeah, I just had an appointment and stuff this morning, and now I'm ready to go. And sorry that I was late. Also,
You were not late. You were not late.
Well,
I was early. I was early.
Okay.
Well, blame Judge Bev. We're all blaming Judge Bev. Get on the blame Judge Bev bandwagon with us. Come on.
Okay. Okay. I don't like her anyway, so that's easy. I'll join. But no, I did hear about these interviews though with the jurors, and I didn't see them, but Tess was saying that, you know, they were wondering why Tylee didn't testify. Can you imagine? Because a huge part of the story was left out, and now they're going to go learn it all.
Yes. Yes. I can't.
Crazy.
I mean, I can't imagine if I were sitting in that courtroom and it was my job to hear this evidence and then deliberate later on guilt or innocence. And we're hearing these names of these people, and yet that's it. We're just hearing these, like,
yep.
There's no, that nothing that they said at the time or, after or in the courtroom or any of that. And I think that when this juror says a part of the story was missing, remember, they're not being asked to know why she did this. Motive is not something that they have to prove. Okay. They only have to prove that she was part of a conspiracy. And according to the jury, that's what they did. And I think what she's talking about is not that there wasn't enough evidence of a conspiracy for the jury to convict her. Obviously they did. Okay. Right. She's clearly talking about these other characters that were referenced repeatedly in the trial that they never heard from in any capacity.
Right.
Even though they showed from the body cam footage, they showed Alex, but it was muted. There was no audio. They couldn't hear him. So, I mean, I think that's what I'm about 99.99999% sure that that's what she meant. All right.
Yeah.
Yeah. And here comes Nate. Did she have any valid arguments? I love Nate.
No, Nate.
No, she didn't. And then the jury is going to be like, no. All right, here we go.
Story that was missing.
Did she have any valid arguments? Like anything that made you think maybe she's not guilty?
Do you want to answer? I can't think of any.
Honestly, up until yesterday, I would have said not guilty. But when the prosecutor, I don't know, what do they call that? When they give
closing argument?
Yes, the closing
Connected
argument.
the
That's
dots.
really, there's a few things she said in there. And when I looked them up today, I was like, oh, yeah, that's bad.
And you were still on the fence yesterday.
I was yesterday. Yeah.
Give us a sense of what it
Okay. I can't remember. This is what he said right here is very important. Okay. And this is why closing arguments are important. But you have to listen to what he's actually saying. He's not saying that he heard the closing arguments and used those closing arguments as if they were evidence and use those in his deliberations. That's not what he's saying. What he said is that she, during her closing arguments, she connected the dots. And when he went and looked it up, which means looked at the evidence that was presented in court, then he realized how those dots were connected. That's what a closing argument does. It points the jury in the direction of the highlight reel of the entire trial. And they use the highlight reel and they're like, oh, I forgot about that. Let me go look at that piece of evidence. They're not using
Right.
the closing argument as evidence.
Right. Yes. A lot of this stuff, though, people don't know. I didn't know, until watching. Unless you spend some time watching trials and stuff, you really don't know some of this stuff.
Right. I mean, I don't know this stuff because I'm a freaking attorney. I know this stuff because I've watched trials over
Right.
and over and over and over.
Yep.
But I did see something somewhere that about this specific comment, and it just went all over me because the interpretation was wrong. And I just needed to point that out for my own peace of mind.
Yeah.
That's it.
Just also regarding like Lorie and stuff, I saw Colby. He was live during the verdict.
He was.
And he was crying and stuff. And, there was I think almost 20,000 people watching live. Which,
how many?
Almost 20. I saw it at 16 or 17,000.
Wow.
I'm
Good
pretty
for you,
sure.
Colby.
Yeah, it was a lot. And I'm pretty sure that was it. If somebody knows exactly, feel free to let me know. But regardless of all of that, I just want to say I think it's awesome to see him getting support.
Yes.
He doesn't have anybody, so it's cool to see. Think about it, his whole family. Now he started as a new family, but his whole family has been destroyed by this. I do hope in the future, I'm curious, will he go on to talk about other cases? I hope that he does, and I hope that it's not all about Lorie. He could help so many people. Think about Harley. And, Harley has talked about she wanted to speak out and let people know, if you're in this position, come talk to me. I'd like to help people because you don't know what to do. So it'd just be really interesting to see kind of what he does with this, because he has this, I don't know, he could do something really awesome. And yeah, what do you think he'll do?
I hope that he does. I hope that he takes this horrible experience, because, people like Colby and Harley, they belong to a club that you don't want to be a member of. And I think that the way that he's kept his sense of humor, the whole situation with the green enchiladas, okay? It's one thing for me or Allie or, somebody who's an outsider to this is just commentating and just watching it to, see the humor in that situation, okay? It's another thing for the person whose mother it is, who these unremarkable, unmemorable green chili chicken enchiladas, she's the cooker of those. She made them, right? And he saw the humor in that. And I think that speaks volumes to Colby's character. I think that I think he's moving through this the best he can, in the best way that he knows how. And I do think that he could really help the family members, particularly the children of the parent who does something heinous.
Yeah.
Because there's not a huge difference between Letitia Stout and Lorie Vallow Daybell. There's not. They're both child murderers. The end. Why they did it is their reasoning may be different, and how they covered it up is different, but their crime is the same. They're child killers. And so, being the child of a child killer has, when it's their own child. Letitia's a mother who kills. Lorie is a mother who kills. Period.
Yep.
Slice it. And the way that impacts the other children in the family, I think Colby would be an excellent resource for other children who are now adults, but children of mothers who kill or fathers who kill. I think he would be great.
Yeah, I hope he does that and kind of can get away at least a little bit from his mom, get out from under that, but still use it to help him. And I know that Tessa is now a mod there, and she said that she recommended to him to talk to Harley. So it'll be interesting if they do.
Oh, good. I mean, they should. I would be great. Harley, Colby would be a tremendous resource.
Yeah.
And just there's not going to be a whole lot of people on the planet that are going to understand what you're talking about. And really, truly, we can sympathize, but we cannot empathize. The only people that can empathize are somebody that's been through it too. And most of us haven't been through it. And you're going to say things, you and Colby will have conversations and connect on a level that we'll never be able to. And I would hope that if Colby does reach out to her, that she is receptive, because I think it would be a good resource. I think it would be helpful to both of them, really.
Yeah, me too. I definitely agree. Okay, I got to ask you though, because someone put in the chat, like, this is going to be a stressful trial talking about Stephan. And I know we're talking about Lorie, but we're here for Stephan. So
we are.
Are you nervous about streaming that? Because I mean, I know you'll do a great job, but it's just going to be so tough, like the information. And I wonder how much will they let us hear? But yeah, what do you think?
It is going to be like emotionally tough because of the subject matter. But I am firm in my belief that what I'm hoping can come from this, besides justice and Stephan Sterns being held accountable and held criminally responsible and get his just desserts, as it were, that somewhere along the way, it won't come from the defense, obviously, but from the state, during their presentation of evidence, that something will resonate with someone about the way that Stephan Sterns went about committing this crime, and it will resonate with somebody else. And if just one child can be saved, can be protected, and and this can, hopefully be prevented, then I think whatever discomfort that it causes me, whatever emotional issues it causes for me personally, I can't speak for other people and I won't, but for me personally, it would be worth it. I can sit through the horror if it helps just one child.
Yeah, and it totally could, because the signs, people could see signs that maybe they didn't in their own life that they didn't see before until watching it. Just having the conversation opens that up for a possibility. But I'm also a believer of, hey, if they had to go through it, we can go through hearing the details.
Exactly. Absolutely. This was what happened to Maddie. So this is what she endured. And if she endured it, I do agree with Allie. We both have said this many times. No, Joe, you haven't missed it yet. It hasn't even started. This is just me and Allie talking about stuff before it starts. I think that if she had to endure it, and we want to in any way honor the victim and be true to the victim, which is Maddie in this case, as horrible as these details are, they are part of, it's not her whole story, it's part of her story. Maddie was a whole person aside from being a victim, but this is a part of her story. And I think we owe it to her to sit through it and listen to it, as hard as it is.
Yeah, agree.
But should people need to step away, or should they not be able to sit through it? I would not judge. I'm talking about I'm going to do it. It's a choice for me. Everybody should do what's right for them.
Yeah, because depending on what someone's been through in their life or whatever, this could be really upsetting. And yeah, I think though, like just doing it as far as being up on the panel is probably nerve-wracking. Like I can imagine, because you'd probably, I don't know. I just feel like I'd be gauging my reactions, but I do that anyways, like in regular, when we're going through the details. I just can't wait, and I'm glad you're doing it. And I want to hear all the details. I know that you'll handle it in a professional but loving way. I know that
Thank
you
you.
will. So yeah, I hope they'll give us as much as we can, hear. But
Speaking of professionals, if you missed it last night, Allie went over the interview that Stephan Sterns' parents gave very recently. Now, they were not on the panel, but B. Crumbs went through and got all the questions and the answers, and Allie went through them. And you did an amazing job yesterday. You made me think. Like, I did take a step back and wonder if when we were listening to those phone calls and it went all over me and I might have come out of my hair a little bit and said some things, if I misinterpreted what I was hearing. Was I hearing justification, or is it possible that because I don't know these people, what came out across to me as justification actually might have been some sort of reflection, that they're trying to understand how this happened?
yeah, I think that's part of it, but I don't know. I've been like thinking about this all night, right? And I know we talked about maybe talking about it, but I don't know. Also, Letitia, there's been another filing in her lawsuit, but so maybe we can just talk about it. Like, I wish I had my computer so I could pull up though, because I wanted to get your reaction on some. Let me just say, it's hard because part of me wants to. Because I can understand the creator being kind to them, wanting to talk to them, I do want to hear from them. I want to know, like, I'm just curious of, just like when we're looking at Letitia's psychologically, I want to know, like, how a person turns out like this. And I think that the parents have a lot of answers there. But also, like, I'm torn because they're, making excuses. And I will say the original interview, like, the creator comes on and outwardly flat out says at first, Jen was helping. She was selling some of these pictures online. And then she gets pressed and she's like, no, this is just my belief. There is no evidence of it. So it's like really different than how we do things, right? Because we
would
want to see
never
proof. Yeah.
We can be having the biggest side eye of all times, but we'll be quiet about it publicly until there's evidence that we can speak about the side eye that we had.
Yeah. And no offense to the creator, but I gotta say, like, I don't work that way. And I feel like his mom is really fueling that. And at the end of the day, like, Jen, there's no evidence of that yet. And if there was, she would be charged, period, flat out. Those cops were not happy with her. They would have been thrilled to be able to charge her. So it's not good to make connections that aren't there. So I don't know, like, I'm going back and forth with myself how I feel about the whole interview and everything, but it is what it is. We'll see.
I mean, I do think, and this is what I would say to Stephan Sterns' mom. Okay. I don't know what happened. I don't know what degree, if any, or level of involvement she may or may not have had, Jennifer Soto, that is. But if you continue to focus on that, it's going to be really hard for you to get through this. And I'm going to tell you why. Because regardless of what her level of involvement is in this or not in this, it changes nothing for your son. That's it. That's all. Even if she, let's say for argument's sake, this is only for argument's sake. Let's say she is complicit. Let's say she was a total accomplice. Okay. The only thing that changes is now there are two people charged. It doesn't help your son in any way, shape, or form. He's still on the CSAM trial is coming up. Then he's got the murder trial coming up. And at the end of the day, he's in line. If he's convicted, he can receive capital punishment. Which I know what that means. So how does focusing your energy on trying to turn the public against Jennifer help you or your son? The answer is it doesn't. That's a rhetorical question, by the way. You don't need to answer it because the truth is it doesn't. It doesn't help him.
Yeah. And like then like it's everything to kind of take responsibility from him, right? It's Jen, and then they're talking about the traumatic brain injury, and how the medical professionals could have missed something that could have prevented this, which is ridiculous. And then talking about Maddie, they talk about it as if he was like her, as if they act like almost like it was a real relationship. And here's the thing: even if, like I said yesterday, if she consented, she can't consent. We know that. That's bullshit. I don't want to hear that. And here's the other thing: they know now that there was 35,000 images of CSAM on that hard drive
that were not Maddie's.
Yes, that weren't Maddie, and they didn't know that during the calls, but they know now. So shouldn't there? I don't know. It's just,
you would think that there would be some sort of light going off, right?
Yeah.
That they would be like, oh, maybe in the beginning there was a level of denial, but now that all of the evidence, or a great deal of evidence, has come out, specifically the evidence that Allie just referenced, you'd think that they would have a light bulb moment.
Yeah.
And just either accept the situation for the way that it is and try to move through it the best way they can, or shut the fuck up about it and stop trying to talk about the situation. Even with, like, yesterday, one of the responses to one of the questions, I don't even remember what the question was because I was making dinner, but I just remember the response. And the response was regarding how Jennifer Soto and Stephan Sterns even got in a relationship. Because this is the second time I've heard the phrase, it was her idea.
Yeah.
Okay. And we're talking about in one situation, we're talking about an adult, a grown woman. Okay. And in the second situation, we're talking about a child, not just a minor. Because when all of this started, Maddie was a child. When she was murdered, she was barely a teenager. Like, she had just become a teenager. And he took her life. Those are two very different scenarios and situations. And yet the way that the mother talks about them, it's as if they are the same. And they are not, Deb. And that's why people, hi, it's me. I'm people. That's why people have a problem with you. Now, I'm trying to extend you some good motherly advice, okay? You should probably take it.
Yeah, and here's the thing, though. They don't want other people to have any opinions back, but how can you not when they're saying the things they're saying? I don't agree, and I know you would never. Our opinions are going to be respectful. They're not going to be attacking them or anything like that. But don't open up the conversation if you're not ready for the response, because not all of, I'm sorry, Stephan is the one who he's charged with this. Okay. And he did this, and there is a lot of evidence. You have to stop and, just accept the opinions if you're going to start the conversation, because there's going to be responses.
Exactly. And part of me, okay, I agree with part of your comment here, Patricia, but the other part I disagree with. So Patricia says, nobody needs to turn anybody against Jen. I'm aghast that she has not been charged with trafficking her daughter. She's only free because of an immunity deal. Let's not forget. Okay. I have to, it's not that I disagree. I just need to correct the last sentence. Okay. She does not have an immunity deal. And to be fair, you might have been able to say more if YouTube didn't limit you to 150 characters. But I have to remind people, it is called diffuse? No. Derivative use immunity. Thank you, Allie. Which only pertains to that interview. She doesn't have immunity. This is not a situation like what's Kayla Montgomery. This is not that. Okay. Right. Kayla Montgomery had full immunity. She was not going to be prosecuted except for the perjury that she committed at the grand jury. Okay. That's very different than the deal that that Jennifer Soto got. And I want to make that clear because that is important.
Yeah, it is. But here's the problem. I saw other creators, which this will be on me, not Jen. So take what I say. It's me. Like BHB, who doesn't know shit about the case, who jumped on when that interview came out and started saying, Jen Soto has immunity. Jen Soto has immunity. That is not true. She has immunity for the one interview, just anything that she told them they can't use against her. That is it. And if it is disagreeable with what she had said previous, they won't use that against her. That's it. If there was evidence of her being a part of her having anything to do with the CSAM, or if they were selling photos or whatever, like Stephan's parents have tried to say and many people have tried to say, police would have charged her. That Detective Kevin, what was his name? O'Malley, I think. I don't remember his last name, but he was pissed at Jen. He would charge her if he could. They would charge if they could. They said to Stephan's dad, we got to remember there was a phone call put out of him talking to police, an interview last summer where they said, look, we are trying to find evidence. We've looked high and low through all the electronics, through everything. We have not found the evidence that shows she was doing this with him, because the dad kept heavily implying, that she was doing just as much as Stephan was. She was a part of it with him. There's just no evidence of that. That doesn't mean that she's not to blame, because she takes a lot of fucking blame in this,
Yes,
or a
she
lot
does.
of freaking blame in this.
No, it's fine. You say what you need to say.
Thank you, Jen. She takes a lot of blame in this, and I understand people are so furious with her, and I am too. It's so disgusting that she's more concerned with him getting an attorney and just all the shit she says and being so selfish. But we can't put things on her that we don't have evidence for.
Right. Yes, I agree with Allie. And let me say this. Jennifer Soto, there is enough things that she has done, that she has admitted to, that there is evidence of, that we can blame her for and be angry at her for, without adding additional things for which she has not been charged and it has not admitted to, and there is no evidence of.
Yes.
That's our point. That's it. Not she didn't do anything, she's innocent, blah, 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 blah. No, we're not saying that. What we're saying is this is what Jennifer Soto is guilty of, in my opinion. She is guilty of neglect. She is guilty of trusting somebody she had barely known with the most precious thing she had in her life, which is her daughter.
Yeah.
She's guilty of being lazy. She's guilty of a lot of things that she's admitted to.
Yeah.
But we don't know about these other things that people are saying that she was a part of, that she was doing, because they haven't charged her with that. That's all.
Yeah. And it's so important. I'm glad we're having this conversation, because it's like the word true and true crime means nothing to some people. And especially if it helps get a video out, or, if something's salacious, it's going to get more attention. This is supposed to be true crime. We're supposed to be going through the facts and the evidence, black and white. Take your feelings out of it for a second. We have to, because my feelings say, if I saw Jen in person and I was back in my day, I probably would have wanted to kick her ass my damn self. Right? I'm mad at her too, but we have to take that out of it and look at the actual facts and bring back the true and true crime, because I'm so tired of just the not true shit going around.
Exactly. And Rachel's got it right again. My guess is law enforcement wants her charged more than we do. Yes.
Yep.
Listen, some of you guys didn't follow Sarah Boone with me. Okay. But we're about to watch it because, I just wanted you guys to see Stephan's new do. He's shaved his head. He looks even more pathetic. And by the way, Stephan, you don't look like you've lost any weight from this appearance, from this current appearance here, than you did from your first appearance. You need to stop. I don't know what it is about certain people that when they get charged, arrested with a very specific crime, all of a sudden they become, they've wasted away to practically nothing. You don't look like you've lost 1 ounce, unless you count your hair. And even that, stop it. Okay. Stop being dramatic. All right. If it were up to me, never mind. I'll leave it there. Anywho, the one of the prosecutors in this case is Mr. J, who prosecuted Sarah Boone. He cared and cares about victims. He cares about George Torres. Okay. When it would have been really easy for him to cut a deal with Sarah, and he could have made it really easy on her. You know what was hanging her up about the deal? Mr. J and Mr. Cacciatore were emphatic that in order that she had to admit guilt if she were to get that plea deal, and she freaking refused to do it. And the reason they wanted her to admit guilt is because they wanted her to acknowledge that George Torres's life meant something. He wasn't a perfect person. He was flawed. He had he had a lot of issues, you know, but he is still a human being, and he deserved better. And his life meant something, and she took his life. And they wanted her to acknowledge that. And if that's the way he felt about George Torres Jr., imagine how he feels about Madeline Soto. So if you guys think that there is some sort of evidence out there and they're just refusing to charge Jennifer Soto, which, by the way, in her derivative use immunity, if it is found that she lied during that interview, guess where that derivative use immunity goes? Out the window, down the street, into another town. It's gone. It's over. It's done. She doesn't get it anymore. Okay. So don't you think that they are likely trying to find any lie in that? Any lie.
Oh, yeah. And it's so cool that you have experience with this prosecutor like that. Like, because I watched you some with Sarah Boone. That's the most I knew of it. And that
was my best trial ever, Allie. I was hilarious. I don't want to toot my own horn, but toot, toot. I was hilarious during that trial.
You've done great on that case in general. The trial is just a small part of it, in my opinion, because you're the only person I've ever watched on that case. But it's so cool that you have like you have experience with this prosecutor, because you kind of have already learned how he works and stuff. So I think that's another reason to watch the trial here, in my opinion, because to hear that perspective. But you're so right. If they could, they would, they would, and they might, maybe they will still find evidence. I don't know. But at the end of the day, bring back the true crime. And and it's so interesting though that the prosecutor is dedicated to the victims like that, because think about it. You're right. How would he look at Maddie, this innocent child?
Absolutely.
Who you can't say anything about, and who doesn't have a shady history or whatever. Like,
absolutely. Like, yes, I'm telling you guys, if you don't listen to anything else that I say about Mr. J, about anything, listen to this about Mr. J. He takes his job as a prosecutor and his responsibility to the victim very, very seriously, regardless of who the victim is.
Yeah.
And so if he felt that passionate about George Torres Jr. and his life, I can guarantee you he feels just as passionate, if not more, for Madeline Soto. Okay. And there is no way that he is not going to prosecute this crime. If Jennifer Soto, if there is evidence that Jennifer Soto lied or was complicit in any way, shape, or form, and he thinks that he can prove it, he's going to charge her. I promise you. So, you guys are all free to have your opinion in the chat. And I understand the anger and the outrage. Believe me, I do. So just please be careful what you're putting in the chat, okay? Please, for me, I'm asking you nicely. So we have like about 5 minutes before they're supposed to go live, like 4 minutes and 22 seconds. Hey, Allie.
Sorry, that was my child. ask him if I have a stain remover he can use. He had to call instead of just walk over here and get it. But but dang, I was gonna say something, Jen. We learned something else in this interview. That was interesting. So
Okay.
remember, we had talked about and heard that Jen was in the hospital.
Yes.
And apparently his mom is the one who kind of started that and put that out. And it just came from a comment from supposedly one of her cousins. Like, so we don't even know for sure if that's true.
Right. Which is
So,
interesting to me. Interesting to me. You know?
yeah, me too.
You know, I think that I think that I'm curious about that whole how that all came to be, and I do want to get to the truth of that matter. Was she or wasn't she in the hospital?
Yeah,
You
me
know,
too.
because
Yep.
those details do matter. You know, because you
Yes.
can. I mean, I know why it would. Okay, I think if let's say for argument's sake, allegedly in that it is his mother who floated this rumor, right? What would she hope to gain from this? Well, basically, it's in my estimation anyway, she would be floating it because look at Jennifer Soto. She's running from her responsibilities to Maddie once again. And she must have done something because look, she's all shook up. They've
Yeah.
got her in the hospital.
Yep. That's what I was thinking. It matters because of her reaction, and it's just good to know. Like, is that true? I believed it because we've heard so much. She's talked so much about her medications and her
Mhm.
mental health, and I mean, hell, she gave Stefan's dad the excuse. That's why they didn't have a sexual relationship together. The two of them, Stefan and Jen. I'm on so many medications. Let me
Right.
excuse away again. Everybody excusing away what Stefan's done. No wonder he's how he
Right.
is.
Right. So, SJ's Sheila, okay, what Jennifer Soto was given is called derivative use immunity. Okay. And this specific instance of derivative use immunity is not immunity for all time, and it's not immunity from anything and everything. It was very specific. It was derivative use immunity for for a single interview, one interview. And if it was found that anything she said during that interview was a lie, then the derivative use immunity would no longer be in play. So it's not temporary immunity. It means something very, very specific. And they don't really need her. They don't need, I don't know why they gave her. I think they just wanted her to talk.
Yep.
Because they don't actually need anything she had. They don't need her to prosecute Stephan Sterns for this crime, either crime. They don't. They don't.
Yep. I think they desperately wanted her to talk because they had the same questions we do. Remember that
Exactly.
interview with the cop yelling at her?
Exactly.
This doesn't make sense. Like, you're not making sense. And you've lied. She lied. She acted like she was the one to take her that morning. There's all these things. The cops
Exactly.
probably were desperate to hear from her, just like we are, and thinking that she could be involved. So they gave her, whatever you tell us, if it's true, we can't use it against you. That's not really that much of me. Like, to me, that if there was evidence of a crime, they can charge her. So it's not that big of a deal.
Correct. And let's think about what they actually told Jennifer Soto when she sat down for that interview. Okay. If you lie to us in this interview, then then there's no more derivative use. Okay. I think they wanted to get her talking, but like Ali said, because they had questions themselves, but also even though her statement, and as long as she tells the truth, that interview, the statement that she made in that interview cannot be used against her. It doesn't mean they can't investigate what she said in that interview to determine whether or not They've started.
Yep. Ooh.
On the record, State of Florida, this is Stephan Michael Sterns, 2024 CF602. Appearances for the record, beginning with the state, please.
And that's Madeline Williams for the state.
The sound is so funky on my end. Let me pull up my laptop.
It's not just you, Allie. It's everybody. It usually happens in Florida. They'll get the sound worked out. Just be patient, you guys.
Okay.
Those of us who've been through Florida courts, we've seen this before. We're familiar with this brand.
Oh, this is Mr. Al, counsel on behalf of Mr. Sterns.
Thank you. Right, the court has three motions before it filed by the defense. The first in chronological order is a motion to suppress evidence obtained by unlawful seizure of a cell phone. The second is motion to suppress evidence obtained from unlawful searches.
Just one question.
Yeah.
About the sound, because this does it to me sometimes with the sound booster on. Is it on?
It is on, but I mean, I can see if I turn it off, if that will do anything, but I don't think that it will, because it's usually, I'm familiar with
the
brand of, yeah. So
Okay.
let's just see.
Okay.
Of a cell phone, and the third motion, motion to suppress evidence
It's
obtained
off,
from
by the way.
search warrant. Some of the arguments are interlaced amongst themselves. The state of Florida has filed responses to each of the motions. In advance of this hearing, the court was provided with three audio recordings of interviews. The first recording of an audio interview was with Mr. Sterns and Detective Hunt. That was on February 27th at 12:05. Second recording was identified as 24-11313 _ Stephan, between Mr. Sterns and Detective Tagler and Detective Costa. Third recording the court reviewed was identified as 24-1313 _ Stephan number 2, and that was an interview that occurred on February 28th at 12:16 a.m. I have reviewed those recordings in their entirety. I have reviewed the defense's motions. Some of the interrelated arguments are that the seizure of Mr. Sterns' cell phone by law enforcement was initially pursuant to consent, but if that consent is deemed valid, that the scope of the consent was exceeded by law enforcement, that consent and subsequent consent were not a knowing, voluntary, or intelligent waiver of his Fourth Amendment rights. That's either that was by way of coercion or acquiescence to police authority or impairment by lack of sleep or ingestion of a sleep aid, and that no exigent circumstances existed to vitiate the need to secure a warrant prior to the seizure. Second motion deals with a request to exclude evidence pursuant to the exclusionary rule, pursuant to an unlawful search of that cell phone. Again, the defense argues that any consent scope was exceeded by law enforcement, that alleged consent was not a knowing, voluntary, or intelligent waiver of Mr. Sterns' Fourth Amendment rights against unlawful search and seizure, again, by way of coercion, acquiescence to police authority, impairment by lack of sleep or use of a sleep aid, and that no exigent circumstances existed for the unlawful search. Third interrelated motion is a fruit of the poisonous tree argument that the subsequent information obtained from a Google search warrant from the initial search and seizure of the phone was pursuant to a warrant. However, the taint was not diminished. The taint of illegal activity was not diminished by the subsequent warrant, that the warrant lacked probable cause, and that the application for the warrant and warrant itself were defective on their face. The state's response is also interrelated on these related
motions indicating that the initial interaction regarding the search and limited seizure of the phone regarding the Google search was consensual. That subsequent consent was knowing, voluntary, and intelligently given to law enforcement, that there was probable cause for the seizure of the cell phone, and that exigent circumstances indeed did exist. They further argue as to the motion to suppress evidence obtained from the Google search warrant, that there was indeed a warrant in this case, that the burden would fall upon the defense to establish standing, and that a recitation of their argument is not evidence to be considered to shift the burden. They also indicate that the warrant had the requisite temporal and peculiarity requirements, and if defective, that law enforcement relied on a good faith exception to conduct the investigation of the Google information. So as to the initial motion to suppress evidence obtained by unlawful seizure of the cell phone, does the state concede standing?
No, Your Honor.
Thank you. Defense?
The defense will invoke the rule of sequestration and call Mr. Stephan Sterns.
Thank you. The rule of sequestration has been invoked. If you are a potential witness in this case, we're going to ask you to please remain outside of the courtroom. Please do not discuss the facts of the case with anyone, including other potential witnesses. Ms. Smith, whenever you're ready. Mr. Sterns, may be a question from counsel table. We're going to swear in Mr. Sterns.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do. All right, can you please state and spell your last name for the record?
Stephan Sterns, S-T-E-R-N-S.
And Mr. Sterns, did you come into contact with law enforcement in January of 2024?
I did.
During your contact with law enforcement, did they seize or take an item from you?
Yes, they did.
What item was that?
That would be my cell phone.
Do you know what type of cell phone it was?
It was a Samsung Galaxy, I believe it was a 24.
And what was your understanding, if any, as to what they were going to do with it?
They were just going to check my Google Maps and check to see if I was logged into Google, and that was it. That was all I agreed to.
Were you shown, or did they have a warrant?
They did not.
No further questions, Judge.
Thank you. Any cross requested?
Yes, Your Honor.
Thank you. Ms. Pinnell?
Can I have just a moment?
Yes.
Mr. Sterns, you briefly discussed having a conversation or being interviewed by Detective Tagler and Detective Acosta on February 27th. Is that correct, of last year?
That's correct.
And pursuant to the questions you were just asked, you had indicated that you did not consent to the search of your cell phone.
I consented only to them looking at the Google Maps and checking to see if I was logged into Google in the first place.
Did you have the opportunity to see what law enforcement was doing on your cell phone?
No, as Acosta was still talking to me, Tagler walked away and began searching all the things that I did not consent to.
Isn't it true that she actually handed your phone back to you?
Briefly, when she told me to input my PIN because it had locked itself.
And Detective Tagler actually mentioned looking at your history, which you okayed, correct? Okay, Your Honor, can we approach?
Yeah, come on up.
Okay, so basically what's going on here is Stephan is trying to get all of the evidence that was found on his phone thrown out. And the reason he's saying that what had happened was it was his understanding and he gave consent only for them to search certain things on the phone, and they went beyond that. And he didn't know, and he didn't give consent.
And the cell phone in question was in fact your cell phone?
Yes, it was.
I don't have any other questions.
Thank you. Any redirect? Thank you. Argument, state?
No, Your Honor.
Court's going to find that there has been record evidence to establish that Mr. Stearns was the person that was affected by an alleged violation of his Fourth Amendment rights, that the property alleged in that violation was admitted to be his, and I'm going to find that the burden has indeed shifted to the state regarding the defense's motion to suppress evidence obtained from the unlawful seizure and search of the cell phone. State, do you anticipate presenting witnesses or evidence?
Yes, Your Honor.
Thank you. I'm going to call your first witness.
The state will call Detective Francis Hunt.
All right, so now what's happened is the judge has said, okay, it was Stephan Sterns' phone, and he is the person affected. So now the defense doesn't have, they've proven what they have to prove. Now the state has to prove that they legally and lawfully got that phone and all of the evidence contained within it all correctly, all legally, lawfully, and properly.
Of course. Attorneys on both sides are welcome to move about the well as they need to.
Good afternoon. Will you please say your first and last name and spell both of them for the record?
Francis, Francis, Hunt, Hunt.
How are you employed?
I'm a detective with the Orange County Sheriff's Office.
What was your assignment with the Orange County Sheriff's Office in February of 2024?
I was and am currently assigned to the Domestic Crime Squad.
How long have you been assigned to that particular squad?
About a year and a half.
How long have you been with the Orange County Sheriff's Office?
About 5 years.
Were you assigned to the investigation into Madeline Soto, who was reported missing?
Yes, ma'am.
Did you have the opportunity to come into contact with somebody identified as Stephan Sterns?
Yes, ma'am.
When did you have contact with Mr. Sterns?
The morning of February 26th, 2024.
February 26th, the Monday, or February 27th, the Tuesday?
I believe it was the Monday, or it was actually the Tuesday morning, I'm sorry.
Tuesday. At the time that you had contact with Mr. Sterns, had the Orange County Sheriff's Office already been investigating the disappearance of 13-year-old Madeline Soto?
Yes, ma'am.
Did you have contact with Mr. Sterns and conduct an interview about 12 in the afternoon on February 27th of 2024?
Yes, ma'am.
And can you describe Mr. Sterns' demeanor during your encounter with him?
Nothing particularly notable. He seemed to have, I think he had just woken up about an hour before I made contact with him. He was an average demeanor, nothing particularly notable about it.
Was he cooperative with you?
Yes, ma'am.
Was he able to speak coherently to you and answer questions appropriately?
Yes, ma'am.
Did he seem to have any difficulty understanding the conversation that you guys were having?
Not at all.
Was this interaction that you had with Mr. Sterns audio recorded?
It was.
Where were you at when you had this interaction with him?
I was at his home or at Jennifer Soto's home in Kissimmee. We were in my vehicle.
Was this located at 4012 Santa Maria Drive in
That's it.
Kissimmee? And was anybody else present during your conversation?
No, ma'am.
Your Honor, I would like to approach the witness with state's name for identification.
Allie, look at this comment. Meanwhile, things that will not be said about Jen Lu when she passes away. I want to make Jen Lu makes me want to be a better person.
Accurate recording of the conversation that you had with Mr. Sterns on February 27th of 2024 at approximately noon.
Yes, ma'am.
Your Honor, at this time, the state would seek to introduce into evidence what's been marked states A for identification and the evidence is states 1.
No objection. A as an alpha will be received as states 1 for purposes of this hearing.
During your interaction, you had indicated that you believe, well, actually here in court today, you indicated that you believed he woke up about an hour before you had contact with him.
I believe so.
What makes you say that?
I had first completed an interview with Jennifer Soto. I had gone back to my vehicle to make a phone call, and I think Stephan was upstairs in the home while I was interviewing Jennifer. When I had gone back in, he walked back down from upstairs and said that he had recently woken up within the hour.
So not sleep deprived as has been alleged by the defense.
No further questions.
Cross-examination.
Hang on, before the cross-examination, Sprinkle Donut said, Jen Lu, reread that. I don't want you to think I was saying something bad about you. I don't, babe. I'm the most self-deprecating person ever. And I know you weren't saying anything bad about me, babe. I just thought it was funny because I was talking yesterday about what would people say about me if I passed away. That's all. All right, here we go.
Good afternoon, Detective.
Good afternoon.
So just to be clear, when you're doing this interview, you're inside of the house, right?
I was in my vehicle.
Okay. When you first met with Mr. Sterns, you met him inside the house? Then?
In the house, yes, sir.
Okay. And then you took him outside and put him in your vehicle, right?
Yes, sir.
Okay. And when you did that, that's when you learned about him being sleepy, it sounds like?
I don't think he was sleepy, but it sounded like he had woken up about an hour prior. Yes.
Okay. Woke up about 11 a.m.? Sounds like he was noonish, right?
Correct.
At any point, did you ever seek a warrant for any of the cell phones or anything in this case?
Oh, no, sir.
Okay. Did you ever look at a cell phone?
No.
Did you ever ask him about a cell phone?
No.
Free from? Of course. No further questions.
No, Your Honor.
Detective Hunt, step down.
Yes, Your Honor.
Is he excused from subpoena for today?
Yes, Your Honor.
Thank you, Detective. May I call your next witness?
State calls Detective Myra Tagler.
say your first and last name and spell both of them for the record?
Myra Tagler, Maira, last name Tagler.
How are you employed?
The Orange County Sheriff's Office,
How long have you been with the sheriff's office?
9 years.
In February of 2024, what was your assignment?
I was assigned to the sex crimes unit.
Are you still assigned to that particular unit now?
Yes, ma'am.
How long have you been in that unit?
3 years and 2 months.
Were you working in your capacity as a detective in that unit on February 27th of 2024?
Yes.
Did you become involved in the investigation into the missing juvenile named Madeline Soto?
Yes.
How did you become involved?
I was tasked to assist the primary detective at the time, Detective Hunt, with canvassing.
About what time do you respond to assist in the investigation?
It was about 4 p.m.
And this was on February 27th.
Yes.
And where is the initial location where you responded to?
It was in Hunters Creek,
Did you respond to a residence in Hunters Creek or somewhere else?
somewhere else.
Did you respond to the command post?
Yes.
When you get to the command post, do you learn any information regarding the investigation?
Yes.
What information do you have after leaving the command post? What information did you get?
I was advised of we have LPRs, which is tag readers, and I was advised of the direction of travel that Stephan's vehicle had traveled the day of the incident.
Were you aware on this date and time that Madeline Soto had not gone to school on February 26th?
Yes.
Were you aware that she had not been seen since the morning of February 26th?
Yes.
And the information regarding the tag reader, did law enforcement identify the tag that was on a vehicle that the defendant had access to?
Yes.
And what was some information that you got regarding the location of the defendant's vehicle on the morning of February 26th, the Monday?
He had traveled southbound 3 times on South Jungin Parkway towards Kissimmee, which was away from the direction of Madeline School.
Are all of these times early morning and late morning?
Both.
And then did you also get some information that in the afternoon, the car was traveling in and out of St. Cloud, Florida?
Yes.
Specifically, the travel on southbound South John Young Parkway, were those times consistent with what the defendant had described to law enforcement as his location were?
They were not.
And were these, the initial time was around 8:15 in the morning?
I believe it was 8:10.
And then there was another one around 10 o'clock in the morning?
Yes.
And then almost around noontime?
Yes.
Thank you. Overruled as to leading. I've got a question. The times that you just gave were for identifications of the tag through the LPR system.
And then the afternoon times of going in and out of St. Cloud, do you recall what those were?
I do not.
Did you document those times and locations in your narrative that you drafted for the
Yes.
case? Would looking at your narrative assist in helping you remember the specific times that the vehicle was traveling in and out of St. Cloud?
Yes. Thank you.
Rachel Lee, that is correct.
I'm looking at page 4.
Does page 4 help refresh your memory as to the times that the vehicle was picked up on the Tagler going in and out of St. Cloud?
Yes.
What times was it traveling towards or into St. Cloud?
It says eastbound on US 192 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
And you were equipped with this information at the time that you responded and met with Mr. Sterns in this case?
Yes.
Were you aware as to who the last person to have seen Madeline Soto alive or have seen her was?
Yes.
Who?
Stephan Sterns.
Was that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Acosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Miss Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stephan.
Is there law enforcement conversing with either Jennifer Soto or Stephan Sterns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stephan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stephan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did you receive at that time any information about the sleeping arrangements on February 25th of 2024, the night before?
Yes, Detective Hunt told me that Madeline and Stephan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Equipped with this information, did you come into contact with Stephan Sterns?
Yes.
How did you know who was Stephan Sterns and how to find him in the area?
Detective Hunt pointed him out.
Was your encounter with Mr. Sterns audio recorded?
Yes.
As a detective, what is your uniform, for lack of a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Sterns?
I am not.
How about Detective Louis Acosta?
Same, not in uniform.
Does anybody approach Mr. Sterns with you and Detective Acosta?
No.
Where is Mr. Sterns when you approach him?
We're all standing behind his vehicle.
When you say his vehicle, who are you talking about?
The Lincoln?
So the defendant's Lincoln.
Yes.
And at this point in time, is the defendant handcuffed?
He's not.
Is the defendant free to leave?
Yes.
How is his demeanor, meaning the defendant's demeanor when you're interacting with him?
He was very emotionless, but otherwise able to answer every question that we had for him.
Did the defendant, seem groggy, confused, unable to communicate with you?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Sterns' vehicle, but can you explain to the court where everybody is positioned?
Yes, I was standing on the left side of the trunk. Stephan Sterns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acosta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Sterns' path of travel impeded by either of you?
It was not.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
He did not.
At some point during your interaction with him, do you request for Mr. Sterns to take out his cell phone?
Yes.
Or to look at his cell phone?
Yes.
Can you remember where the cell phone was, where the defendant's cell phone was when you asked this question?
I do not. It was in his possession, but I don't recall where he grabbed the phone from.
Did the defendant consent to allowing you to look at his phone?
Yes.
And do you remember if Mr. Sterns' cell phone was password or passcoded protected?
It was.
Who entered the passcode into the phone?
Stephan.
After Mr. Sterns entered the passcode in the phone and unlocked the phone, what did Mr. Sterns do with the phone?
He handed me the phone.
While you are holding the phone, where are you standing?
In the same position next to Stephan.
Do you hold the phone in a way to allow others to see what is on the phone?
Yes.
Where is Mr. Sterns at as you are looking at the phone?
Directly standing next to me.
And initially, the interaction and how the cell phone comes out, you bring up looking at maps in the phone.
Correct.
Are you familiar with the type of phone that the defendant had?
I am not.
Do you also inquire as to taking a picture of, quote unquote, your history, the defendant's history? Do you remember that?
Yes.
And that's also encompassed in the audio recorded interview.
Correct.
Does the defendant ever communicate to you any limitations on what it is that you're doing?
He does not.
Does the defendant ever attempt, either verbally, physically, or in any type of way, to cease the search of the phone?
He does not.
After you look at the maps, the history, what did you see? Or what did you notice in what you saw on the phone?
I noticed that he had mentioned that he uses Google Maps for basically everything to check locations, the time, places open and close. And I noticed that on his Google history, it was very minimal. There was not a lot of traveling that was consistent to what he had originally said to both Detective Acosta and I. So then after that, I went to his call history and I noticed that there was also not a lot of information on his call history.
And this was after you mentioned looking at his history?
Correct.
And during this entire time, did the defendant ever cease or withdraw his consent, either verbally or physically?
He does not.
After this initial interaction with the cell phone, do you keep the cell phone?
No.
What do you do with it?
I hand it back to Stephan.
Is it at this point that you walk away for a brief period of time?
Yes.
And do you come back?
I do.
Where Mr. Sterns and Detective Acosta are?
Yes.
Did anything about the circumstances surrounding this interaction with Mr. Sterns, either the location, the number of people, where people are standing, did any of that change?
No.
Was Mr. Sterns standing in a similar place as before you left?
Yes.
Was Mr. Sterns still free to leave and out of handcuffs?
Yes.
At approximately 7:57, do you again ask Mr. Sterns to unlock the phone?
Yes.
How does that happen? Explain that process.
He again enters the code and hands me the phone.
At some point, do you bring up the lack of call history to the defendant?
I do.
What was the defendant's explanation?
He said he had accidentally factory reset his phone.
Twice.
After your interaction with him, you knew all of that information that you had previously explained that you knew. You had an opportunity to see things on the phone and the information that you had that the phone was factory reset. What did you do?
At that point, I told him I was going to hold on to his phone.
And that was approximately at 8 p.m., 7:59, 8 p.m. on February 27th of 2024.
Correct.
After this interaction with him, did you secure anything else?
No.
Other than the cell phone, did you secure anything else or?
Oh, I did ask him to refrain from going back in his vehicle.
His vehicle meaning the Lincoln.
Yes.
Was Mr. Sterns able to enter and exit Jennifer Soto's vehicle during the time between your two interviews with him?
Yes.
Was he free to walk about?
Yes.
Did you or Detective Acosta remain where Mr. Sterns and Ms. Soto were?
No.
What were you doing in between your two interviews?
After speaking with Stephan Sterns the first time, Detective Acosta and I went to the front of the apartment complex to speak with management and ask them to review their surveillance.
Okay, so Rachel says, isn't this on audio and video? Yes, but it must be spoken into the record. She must testify as to what she did.
After doing these additional tasks, do you speak to Stephan Sterns a second time?
Yes.
This is approximately 12:15 in the morning on February 28th, right?
Yes.
Was Mr. Sterns handcuffed?
He was not.
Had his movements been restricted in any way by you during your conversation?
No.
Were you wearing the same clothes that you had worn a couple hours earlier?
I was.
Who was with you when you spoke with Mr. Sterns?
Detective Acosta.
At any point in time during either of your interactions with Mr. Sterns, did you or Detective Acosta remove a firearm from your persons? Did you guys take your guns out?
No.
Did you threaten arrest or anything like that during your interactions with Mr. Sterns?
No.
This second interview that you conducted, was that also audio recorded?
Yes.
Was Mr. Sterns free to leave at the end of the interview?
Yes.
In fact, he did leave your presence as well as Nation Bay, correct?
Correct.
Was Mr. Sterns' demeanor the same or different?
It was the same.
Did you have any issue communicating with Mr. Sterns?
I did not.
Was Mr. Sterns cooperative with you?
Yes.
And during this second interview, did you explain what law enforcement was seeking to do with Mr. Sterns' phone?
I did.
What did you tell him?
I asked him we wanted to, or I told him that we wanted to download the phone to see if we can get more information from his maps. And then he said that that was fine.
Are you sure that you specifically said that you wanted to download information, specifically the maps?
Not just the maps, just any information on his phone. I told him that we wanted to get more information from his cell phone.
Do you remember using the words, we want to download your phone, we want to go through your phone?
Yes.
During this encounter with him, you request specific consent from him to be able to go through the phone, right?
Yes.
Do you explain to him in your question what is going to happen or what your alternative route to obtaining that cell phone download is?
Yes.
What did you say?
When I explained to him what we wanted to do with the cell phone, I asked him if I had his consent to download the phone or if I had to obtain a search warrant.
And did the defendant consent to downloading the phone?
Yes.
Did the defendant provide you verbally with the passcode to his phone?
He did.
At the time that this interaction happened, did you or Detective Acosta impede or restrict Mr. Sterns' movements in any way?
We did not.
At any point in time, did Mr. Sterns seek to limit the scope of the cell phone download?
He did not.
Did you provide Mr. Sterns with your phone number or a way to get a hold of you after your interaction?
I did.
And did you give him any information as to when you would be accessible through that cell phone?
I did.
What did you tell him?
That my phone was on 24/7.
At any point in time, did Mr. Sterns reach out to you to either withdraw consent or limit the consent?
He did not.
Are you sure that he had a way to communicate with you?
Yes.
How do you know that?
Because Jennifer had her cell phone with her.
Are you sure that, do you know if Mr. Sterns and Ms. Soto left Venetian Bay together?
They did.
Do you know which vehicle they were in?
In Jennifer's vehicle.
I'm approaching the witness for the record with States B for identification. Did you have an opportunity to listen to the recordings on States B for identification?
I did.
Did they fairly and accurately depict the recordings of the two interviews that we discussed here in court with yourself, Detective Acosta, and the defendant in this case?
Yes.
Now, just for fair use commentary purposes, let's keep in mind what Stephan Sterns is alleging here, okay? He's saying that he gave somewhat of a consent to search his phone, but it was a limited consent. He said that he was under duress and he said he wasn't sleeping. We know that that is lies, and here's how we know that that is lies. Because he deleted everything on his phone. That's why he didn't give a rat's fat kneecap that they were searching his phone. He didn't think they would be able to find it. Stop playing with these people and wasting time and money, Stephan Sterns.
Your Honor, at this time, the state received interviews and evidence what's been marked B for identification and evidence of state 2.
Be a composite exhibit with both recorders?
Yes, Your Honor.
Thank you.
No objection.
These and Bravo will be received as State 2.
Cross-Examination.
Good afternoon, Detective. So your interactions with Stephan Sterns, they were audio recorded, right?
Correct.
Okay, they weren't video recorded?
No.
Okay. And let's paint that picture. When you arrived on scene, you said that it was you and another detective present, right?
Correct.
Actually, I think it would have been 3 detectives, right? You, Acosta, and Hunt?
Hunt was already on scene. Detective Acosta and I arrived later.
Okay, so 3 detectives now on scene.
Correct.
Okay. And patrol deputies, right? Were they wearing uniform?
Yes.
Did they have their badges?
Yes.
Did they have their guns?
Yes.
Did you have your gun?
I did.
And did you have their badge?
I did.
Okay. And when you arrive on scene, you said that you first went to talk to Detective Hunt, right?
Yes.
Okay. And then afterwards, at one point you start talking to Stephan Sterns, right?
Yes.
Okay. And this is outside of his house?
Correct.
Because he's not allowed to go inside his house at this point, right?
Not at this point. The house was not secured.
Right. And when you're talking about secured, that's for securing for searching the house, right?
Correct.
Okay.
Nobody's doing that.
Okay. So, at what point, let me ask it this way. How did he get outside of the house?
I don't know. I wasn't there when he was outside.
To your understanding, how did he get outside?
I'm not sure.
Would law enforcement have told him to?
I wasn't there.
Okay. And when you're talking with him, at no point did you say, you can go back inside, right?
I did not.
At no point did you say, you're free to leave, you can drive away, right?
I did not.
Actually, and you kept him from going inside his own vehicle, right?
I did.
Because that was being secured for searching too, right?
At that time, I just asked him to refrain from going back in his vehicle.
Okay, so you didn't even tell him it was for search?
Not at that time. I wasn't sure what we had at the moment.
Okay. And then when you're talking with Mr. Sterns, you kind of give us a general overview that you said that he consented to searching his phone, right?
Yes.
Okay. Your specific question to him at first, going through the timeline, is do you mind if I look at your maps real quick, right?
Correct.
At no point did you say, do you mind if I dig through your entire phone at this point, right?
I did not.
Okay. And then when you get to the next question, it's do you mind if I take a picture of your history, right?
Yes.
Okay. Not take a picture of his lock screen?
No.
Not take a picture of his home screen?
No.
Not take a picture of his call history?
It was his history.
Not take a picture of his emails?
I did not.
Not take a picture of the entirety of his phone, just his history, right?
Correct.
Okay. And then when you get to the next thing, you say, is it okay, let me make sure this is right. Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google, right?
Yes.
And at that point, Mr. Sterns tells you that he is not logged into his Google, right?
Correct.
Okay. But then you keep pressing and you say, is it okay if I check?
I asked. I didn't press.
Okay. You asked if it's okay you checked?
Yes.
Okay. And at that point, it was just to check whether he was logged into his Google, right?
Correct.
Not going through the entirety of his phone.
Correct.
You never asked him, can I go through the entirety of your phone?
He was standing next to me while I was on his phone.
Okay, so it's your basis that he has to say no, you can just keep digging until he says stop?
Correct.
Really?
He was standing next to me and he saw what I was doing on his cell phone.
And did you ever ask him to go through the rest of your cell phone?
I did not.
Did you ever ask him to go into his call history?
I did not.
Did you ever ask him to go through his Google Drive on the phone, if it was it?
I never looked at his Google Drive.
Okay. But you were looking at the rest of his phone, right?
I looked at his call history and his Google Maps.
Okay, because you were trying to figure out that timeline, right?
Correct.
It's the only thing you were looking for at this point, right?
Correct.
Okay. Did you ever go into the photos on his phone?
Yes.
While he was there?
Yeah, he was standing next to me.
Okay. Did you ever ask him if you could go through his photos?
I did not.
Right. And when you're going through those photos, I mean, let's talk about that. How many of his photos did you look at?
I think it was maybe 2 or 3 of the day Madeline went missing.
Just to be clear, you're not just looking at like the big grid, you start going into actual pictures?
I don't recall if I actually clicked on any of the pictures.
Okay, so how do you know that you were just looking at 2 or 3 of the photos?
Because it has dates on, like if you look at the grid, it shows dates for pictures.
Okay. And at any point, I'm just rephrase, at no point did you ask him to look at his photos?
I did not.
Then you go back to his Maps app at some point, right?
Correct.
And at that point, you're talking to him about the Snug Street address, right?
Yes,
Okay, and you never asked him if he could go back to the Maps app at that point, right?
I did not.
Okay. And just to be clear, nothing is visually recorded at this point.
Correct.
So when you say that you handed him his phone back, you never actually said, hey, here's your phone back, or anything like that?
I did. I said, here you go.
Here you go. Now, when you get the phone back from him, what do you say?
I said, can you please unlock your phone again?
Okay. And at that point, it was still you and Detective Acosta standing with him, right?
Correct.
Because you both were kind of tag teaming him, questioning him, right?
We're both talking to him.
Okay. Specifically, at what point did you say, here you go, when you handed him his phone back?
Right before I stepped away.
Okay. You sure here you go are your exact words?
I don't know if it was my exact words, but I did hand him the phone and I said, here you go. It's in the audio recording.
Okay. And then at this point, you said you got him to unlock his phone again, right?
Yes.
And that's when you started digging through his call history, right?
I'm not sure what I looked at when I had the phone back.
Well, you specifically said, I also noticed I was checking your call history. I noticed you don't have anything before this morning, right?
Yes.
Okay. And at no point did you ask if you can go into his call history?
I did not.
You took the phone from him, what time was that?
About 8, a little after 8?
8 at night?
Yes.
Okay. Just to make sure we're painting that picture clear too. 8 o'clock at night you're speaking with him, right?
Correct.
It's about 50 to 60 degrees outside?
Correct.
Okay. And law enforcement's been standing around with Mr. Sterns outside?
He went to Jennifer's car after me and him spoke.
Okay, but before you and him spoke?
I can't answer that question. I wasn't there.
Okay, when you first showed up, where was he?
Outside.
Outside where?
I don't recall the exact location, but he was outside with Jennifer.
Right, so you know exactly where you walked, but not where he was?
Correct. I walked towards Detective Hunt.
Now, at this point, you collect Mr. Sterns' phone away from him for the final time that he has his hands on, right?
Correct.
And when you take that phone away from him, you don't ask him for his phone. You take it from him, right?
I already had the phone.
Oh, right. And then you told him specifically that at this point, we're keeping your phone.
Correct.
Okay. Didn't give him a choice.
I said, I'm going to keep your phone. We want to download your phone.
Excuse me, what was the exact phrasing that you just said there?
That we wanted to download the cell phone.
You said that during the first interview.
The second interview, not the first
Second.
one.
Talking about when you took the phone away from him, the first time, during the first interview. When did you tell him that you were going to download the phone?
The second time.
During the first interview, when did you tell him that you were going to download it?
The second time I spoke to him, not the first time.
You never said it the first time.
I did not.
Right. And then when you're talking with him that second time, you actually state to him, your exact words are,
Objection improper.
response? I'll rephrase it. When you speak with him, did you tell him that we had previously said that we were going to download the phone?
Yes.
And your interactions with him were recorded?
Correct.
And when you originally took the phone from Stephan Sterns, Mr. Sterns was concerned about staying in touch with his father, right?
Correct.
Okay. And that's the point where you told him, well, you can just talk to him through Jen's phone, right?
Yes.
And at no point was he asked to consent to seizing his phone, right?
Correct.
At no point did you ever give him any form or anything to consent to seizing his phone?
I did not. Everything's audio recorded.
Okay. And at no point did you ever get a form from him consenting to downloading his phone?
I did not.
Okay. Because everything's audio recorded.
Correct.
Got it. And collect the phone at 8 at night. It's about 1:30 in the morning you talk to Colby again.
It's not. It's about midnight.
About midnight, okay. 4 hours then?
Just about.
Okay. You had the phone in your possession?
It was in my vehicle.
Okay. Ever apply for a search warrant at that point?
I did not.
Why not?
I didn't need. I didn't have like enough information yet as to what we were doing with the case.
Elaborate on that for me. What do you mean you didn't have enough information?
We knew that something didn't sound right, as like was speaking with him with like the timeline and things like that. But we weren't sure exactly what we were doing yet. I was waiting for my supervisor to contact me.
Okay. And when your supervisor contacted you, did he or she, excuse me? He? Did he tell you to get a warrant?
He did not.
Okay. Did he tell you to try and get that cell phone download?
He did.
Okay. And how did he tell you to get that cell phone download?
He didn't. He just said we wanted to get the phone downloaded, and that's when I asked Stephan if I had his permission to download the phone or if I needed to get a search warrant.
Right. You gave him the ultimatum at that point, right?
I asked him 2 questions.
Okay. So we can either get the phone or you can get a warrant, right?
Correct.
Now, at any point during these interactions, did you ever tell Mr. Sterns that he could have his phone back?
I told him his phone was going to be downloaded overnight and that he should probably get it in the morning.
Okay. And prior to the second interview, did you ever tell him he could have his phone back when you just took it?
I did not.
Okay. At any point, did you ever apply for a search warrant to download Mr. Sterns' phone?
I did not.
Did any other detective do that?
No.
Okay, because you're relying on that consent, right?
He gave us consent to search his phone.
It's a yes or no. Were you relying on the consent or did you get a warrant?
He gave me consent.
Now, when you're speaking with him, you became aware that Mr. Sterns had taken medication, right?
He said he had the night before.
Okay, and that was Ativan?
Yes.
And he told you why he took that medication, right?
Because he said he couldn't sleep and that he was very stressed and couldn't stop crying.
Right, and then he was also having panic attacks, right?
Yes.
Okay. And you knew that?
Yes, the night before.
Why your question? During the first interview?
Correct.
And the second?
Correct.
Got it. You aware what Ativan does?
I don't take Advance, so no.
Okay. You ever deal with anybody that taken Ativan?
No.
Objection relevance.
As to Mr. Sterns, he was wearing flip-flops at the time, right?
Correct.
Khaki shorts?
Yes.
Thin hoodie?
Yes.
Told you he hadn't eaten all day, right?
Yes.
And was prevented from going inside of, sounds like his vehicle, right?
His vehicle, correct.
Okay. And again, couldn't go inside his own house. Or not his house, but the apartment.
Not at the time.
Okay. And at what time, rephrase, at 2:40 in the morning on February 28th, you submitted his phone to the Orange County Sheriff's Digital Forensics Unit, right?
I did not.
You did not?
No.
Who did?
Detective Acosta.
Okay, so Detective Acosta was now in charge of the phone?
Yes.
Okay. You guys ride in the car together?
We did not.
You said the phone was stored in your car at some point, right?
When we were talking, or when we were looking at the video, yes, it was in my vehicle.
When did you turn over the phone to Detective Acosta?
At the end of the night, after we secured the residence, which was around 1 in the morning, Detective Acosta was waiting for the tow truck for Stephan's Lincoln, and that's when I handed him the phone because he was going to Central Operations, and I was not.
Okay. Was that the last time that you had involvement with the phone?
Yes.
Okay. So after the handoff, nothing else, just to be clear.
In reference to, like, if I ever looked at the phone again?
Yeah.
Sure, I think it was like 2 days later.
Okay. So at that point, the phone's still in your law enforcement's possession?
Yes.
To confirm? Of course.
This, in my opinion, all this, he didn't eat, he didn't sleep, is, hold on, much ado about nothing, because quite frankly, it's not as if you were down at the police station and this was going on, that would be much different circumstances. He was at an apartment. He had an opportunity. He did in fact sleep prior. And if he didn't eat, whose fault is that? It's not like he was somewhere where he couldn't eat. Stop it.
Thank you. Redirect.
Defense mentioned that there were other law enforcement personnel that were at the apartment complex. During your interactions with Mr. Sterns, who was in the immediate area?
Just myself and Detective Acosta. Everybody was kind of just hanging out in the area.
Detective Tagler, I've got a question. When you initially interacted with Mr. Sterns, you indicated that you were going to take a photo of his history. Is that correct?
Yes.
Did you take a photo of his history?
Yes.
Was that on your agency cell phone?
Yes.
Any follow-up questions based on that question? State.
No, Your Honor.
Defense. Thank you. Detective, step down.
Yes, Your Honor.
Detective Tagler, excuse.
Yes, Your Honor.
Detective Tagler,
Thank
step
you.
down. Thank you. Seizure up.
Yes, Your Honor. Detective Lewis Acosta.
Can you hear me now?
Yes, I can.
Oh, you couldn't hear me a second ago. But what does it have to do? Okay, so Jen, the night before he takes Ativan, does that mean they're supposed to not ask him to get his phone the next day? I don't understand that.
No, what they're arguing is that essentially he was not with it enough because of the Ativan, because of the lack of sleep, because of the circumstances and the situation to give informed consent, meaning he didn't know what he was saying yes to, which is a bunch of caca. He did know what he was saying yes to. This is the issue. All right. He factory reset that phone to clear everything off of that phone. That's why I believe that he gave them consent to search his phone.
Yep.
Because he did not think they would be able to find anything. This is a good effort by the defense. They had to take a shot. I do not think it's going to be successful.
Yeah, I totally agree with you. I heard you a minute ago when you were saying that. Like, of course, he said they could because he thought they wouldn't find anything.
Exactly.
And, of course, I can see the defense has to try, but also, it's like throwing shit at a wall to see what sticks. I don't think
Exactly. And as Jay Rose points out, I forgot about this. Oops, hold on. Where is it at? I can't get to it. Hold on a second. My mouse is doing something funny. All right, here we go. Jay Rose points out, you cannot question someone on an empty tummy, Jen Lou. That is a human rights violation. It would be if they are the ones that denied him food, and that is what caused the empty tummy syndrome. However, he was at Jen Soto's apartment. He'd been, free to roam about the cabin all day long up until that point. If he'd have wanted to get something to eat, he could have, and he should have, but he didn't. So his empty tummy syndrome is nobody's fault but his own. Case dismissed.
Yeah. Now, Jay Rose, have you been listening to too much Tisha? Because that sounds like something she would say.
Right, Becky. He wasn't in his right mind to make a decision. He didn't have informed consent because he's on Ativan from the night before. Okay, Ativan doesn't have that long of a half-life. Stop playing with these people, Stephan Sterns attorneys. They're trying it. They had to take a shot. It's not going to work. I don't think so. I really don't.
I think you're right, and I really hope and pray that you are.
Yeah. Well, see, here's the this is why they had probable cause, okay? Because they got a story about where he'd been and what he'd been doing, okay? And so when they asked to look at his phone and they're like, where's all the things, right? Because he let them look and all the things are missing. It's very, very limited. They knew right then and there something wasn't right. His story already wasn't making sense. They already had information that his tag had been flagged going away from Madeline's school, which is where he said he was going in the first Sam ass place. So already, basically, to the officer's mind, the milk wasn't clean. They didn't know what was going on with the milk, but they knew something wasn't right. And this is why, he got the fuzzy eyeball. And the only way to figure out what was going on at that point was to download his phone. But he thought, oh, I factory reset it. There won't be anything for them to download. Sure, here, take it. No problemo. He was wrong. He was wrong. All right, let's keep going.
Dude, that was BS. I was trying to talk back.
Oh, and it cut you off again. What happened? You were just speaking. I heard you. Hold on.
Will you please say your first and last name and spell both for the record?
Luis Acosta, Luis Acosta.
How are you employed?
Orange County Sheriff's Office as a detective.
How long have you been with the sheriff's office?
5 years.
In February of 2024, what was your assignment?
I was a detective with the Orange County Sheriff's Office Sex Crimes Unit.
How long had you been in that unit at that time?
Approximately 6 months.
Are you still assigned to that unit?
Yes.
How did you become involved in the investigation of missing juvenile Madeline Soto?
I was the secondary on-call detective at the time, and I assisted Detective Tagler with the investigation, going over to the command post. We assisted our missing persons unit at that time.
What information did you learn at the command post?
We learned that Maddie Soto had been missing for a little over 24 hours. She was 13 years old. We knew that the last person who had seen her was Mr. Sterns. Just, that basic information.
Okay. Did you also get information regarding LPR tag reader hits on Mr. Sterns' Lincoln?
Yes.
And you also got the timing of those tag reader hits?
Yes.
Did you respond along with Detective Tagler to 4012 Santa Maria Drive in Kissimmee?
Yes.
And did you learn any additional information prior to speaking with Mr. Sterns at that address?
Yes, prior we were briefed of Detective Hunt, who's the initial primary detective assigned, just of additional details. For example, that she slept in the same bed as Mr. Sterns, things like that.
Did you assist in the interview of Mr. Sterns that was conducted by Detective Tagler at approximately 7:16 in the evening?
Yes.
And this would be on February 27th of 2024?
Yes, correct.
Where did this interview take place?
It took place in the parking lot of their of the apartment complex near the residence, Maddie's residence.
Who was in the immediate vicinity as this interview was being conducted?
It was Mr. Sterns, myself, and Detective Tagler in the immediate vicinity.
Where would you say the next closest law enforcement official was?
At least 25 yards away.
Were all of the law enforcement officials within view of where you were?
The ones that were in the parking lot could see the general vicinity of where we were at.
How many law enforcement officials would you say were in the parking lot area of where the interview was conducted?
Maybe 10, fewer than 10.
And were these law enforcement officers engaged in tasks, sitting in vehicle, like what was going on?
Yes, just kind of setting up a perimeter around the area, making sure media didn't get too close, just kind of standing by for tasks.
Scene security?
Scene security.
Did any of these other law enforcement officials have contact besides you, Detective Tagler, and Detective Hunt earlier in the day with Mr. Sterns while you were there?
While we were there? No.
Where were you and Detective Tagler and the defendant standing during this encounter?
We were behind the trunk of a vehicle. I can't recall the specific vehicle.
Was Mr. Sterns' ability to move about freely inhibited by either of you?
It was not.
How about any other law enforcement officer that was there?
No.
Were there any law enforcement vehicles prohibiting other vehicles from leaving the area or anything like that?
No.
What was Mr. Sterns' demeanor during your encounter with him?
Kind of very just matter of fact.
Would you classify his conversation with you as cooperative?
Yes.
What were you and Detective Tagler wearing? Not obviously specifics of what you were wearing, but were you in plain clothes?
We were, yes, plain clothes.
Did either of you ever remove your firearms from their holsters?
No.
Did either of you remove any handcuffs, taser, any type of weapon?
No.
Were there any threats of arrest made?
No.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns, based upon your encounter with him, seem to respond appropriately to questions asked?
In what way?
If you asked a question, did Mr. Sterns respond in a way that was coherent?
Yes.
Did you have any difficulty communicating with Mr. Sterns?
No.
Did Mr. Sterns fall asleep or ask to be excused from the interview?
No.
At some point, did Detective Tagler ask Mr. Sterns to look at his cell phone?
Yes.
Do you recall where the cell phone was during this initial interaction?
When she asked to view his phone, he said yes, and it was within eyesight of him. We were right next to him.
Who had the phone when Detective Tagler asked to look at some of the stuff on the phone?
Mr. Sterns had the phone, and then he gave the phone to Detective Tagler after she asked, and he said yes.
Did Mr. Sterns have to do anything to the phone prior to giving it to Detective Tagler?
He input his passcode to get it.
Where was the defendant and Detective Tagler standing while Detective Tagler was viewing the content of the cell phone?
They were standing shoulder to shoulder next to each other.
Were you asking questions at that point?
Yes.
Were you able to see the content
At some point.
Were you standing next to where Detective Tagler and Mr. Sterns were standing, or somewhere else?
Yes, next to both of them.
Was Mr. Sterns facing the general area of where his cell phone was being displayed from?
Yes.
There is a point in the interview where Detective Tagler steps away. Prior to stepping away, what is done with the cell phone?
She gives the cell phone back to Mr. Sterns.
Do you continue to have a conversation with Mr. Sterns?
Yes.
At any point in time, does Mr. Sterns discuss the content of the cell phone or Detective Tagler's looking through the phone?
No, I don't.
At some point, does Detective Tagler come back?
Yes.
And is the cell phone brought out again?
Yes.
At this point, who had the cell phone?
Still Mr. Sterns.
When Detective Tagler asks for Mr. Sterns to unlock the cell phone again, does he do so?
Yes.
Does he have to enter the passcode again?
Yes.
Are the circumstances surrounding this interaction the same as what you described previously as far as location and people involved, the defendant's ability to leave?
Yes.
At the time that that interview concludes, Detective Tagler keeps Mr. Sterns' cell phone, correct?
Yes.
What information did you have together about the Madeline Soto investigation?
So aside from what we had before, that she had been missing for over 24 hours, he was the last person to see her. There were many inconsistencies surrounding the time frame that he stated. He dropped her off and other things. And then the tag readers and information that we had about his movement.
Had the defendant been straightforward with you and Detective Tagler regarding his movements?
No.
I should be more clear. His movements the morning of February 26, 2024.
He told us certain movements that didn't correlate to the information that we had.
Did you confirm with the defendant that he regularly used his cell phone to get places, look up addresses, get store hours, directions, things like that?
Yes, I believe that was brought up.
Were you aware that there was very limited location data and mapping location data that was in his phone when Detective Tagler checked that?
Yes.
Were you aware also of information that was located in Madeline Soto's cell phone as far as communications between her and the defendant?
Yes.
What information did you have about that?
They communicated extensively, including very late at night.
Were you also present with Detective Tagler at the conclusion of this interview between the second interview that was conducted at 12:15 a.m.?
Yes.
What were you guys doing in that interim time?
So in the interim, we were reviewing surveillance video from the apartment complex to corroborate the times that he came back into the apartment complex.
Did you learn any new information when you did that?
Yes. One of the surveillance videos that we saw, it appeared that there was somebody either asleep, passed out, or not awake on the inside the vehicle.
What exactly did you have information as to the last clothing items that Madeline Soto was reported to wear?
Yes.
Was the individual in the driver's seat or passenger seat is what you just described?
Yes, wearing the same.
Were they in the driver's seat or passenger seat?
Passenger seat, front passenger seat.
What about their appearance makes you believe that they were not awake?
Slumped over, kind of leaning back. Just did not appear to be awake.
And you observed this video between the first and second interviews?
Correct.
And the individual that you just described, was that consistent with the characteristics that you were knowledgeable about Madeline Soto?
Yes.
The second interview, were you present at 12:16 a.m. when Detective Tagler again spoke with the defendant?
Yes.
And it was during this interaction where there was a brief conversation. Did you have a brief conversation with the defendant about what was seen in Madeline Soto's phone?
Yes.
Did the defendant attempt to explain that to you?
Yes.
What did he say?
He initially said she thought of him as a father figure. Then he immediately said she thinks of him as a father figure. Just said that it was a father figure-like relationship.
And you also were present when Detective Tagler then speaks about downloading the cell phone.
Yes.
Can you kind of elaborate on that encounter as far as
She explained that we'd be taking the phone, be getting it back whenever the phone download was complete.
did Mr. Sterns limit the download of the cell phone in any way?
No.
Did the defendant refuse to give consent to download the phone?
No.
Did the defendant willingly provide the passcode to his phone?
Yes.
And all of this is recorded, right?
Yes.
At what point do you recall learning that the phone was factory reset?
I believe during the first interview, while Detective Tagler was looking through the phone, she noticed that the call logs, he only had calls from that day, the date of the interview, so from February 27th. So she asked him about it, why he only had calls from that date. He said he had accidentally factory reset his phone the day prior, attempting to do like just some sort of update. There you go.
As a law enforcement officer, have you had the ability to seize or collect cell phones belonging to individuals during investigations?
Yes.
When a cell phone is taken, are you aware, or do you put the cell phone in airplane mode or secured in any way?
Yes, it's placed on airplane mode.
Why?
To prevent it from being remotely reset or anything being deleted remotely.
So you're aware of that possibility?
Yes.
No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So the interactions between you and Stephan Sterns, that was audio recorded, right?
Yes.
Not video recorded?
No.
Okay. And it's my understanding that you have an agency-issued cell phone, right?
Yes.
And that has the ability to document photos as well as videos?
Yes.
Okay. Did you do any of that documentation, the photos and videos, while you were speaking with Mr. Sterns?
I did not.
When you said you arrived on scene, you said there was about 10 other either deputies or officers on scene?
Roughly spread around the parking lot area.
Okay. And you said that they were securing a perimeter, right?
Correct.
Making sure that media wasn't coming in and out of the apartment complex, right?
Yes.
Okay. So that means that there were going to be officers at the main entrance area of the complex?
Yes.
Okay. And they would have been staying right there the entire time, making sure who's coming and going, right?
Yes.
Okay. And then at this point, it sounds like the apartment was getting secured to search it, right?
Yes.
Okay. So does that mean putting up crime scene tape and everything?
I can't recall about the time of the interviews at crime scene.
Okay. Some point it got crime scene tape, though.
Yes.
Okay. And when you say that the officers, deputies, whatever, were in the parking lot, were they just clumped up in one group together or across the entirety of the parking lot?
So some of the detectives were kind of in one group.
And while State asked you if you ever removed your firearm, I just want to clarify, you had your firearm on you, right?
Yes.
And you're in plain clothes at this point, right?
Yes.
So is your firearm just chilling right there on your holster? Or?
Yep. On my hip. Yep.
Yeah. So it's visible?
Yes.
And you said that while you're questioning, well, you and Detective Tagler were questioning Mr. Sterns, you're both standing by a vehicle, right?
Yes.
I don't know whose it is, but it was a vehicle, right?
Yes.
Okay. And at this point, Tagler's questioning him, you're questioning him, he's in the middle of you two, right?
I can't recall where he was between both of us.
Okay. But you're all towards, it sounds like the back of the vehicle?
Yes.
Okay. And you had stated that while Tagler's taking a look at the phone, you're close enough to see the phone, right?
Yes.
Okay, so you can actually see what's happening on the screen?
Yes.
Okay. So it's not like when we're saying that you're standing around the vehicle, somebody's over by the front of the car over here and somebody's all the way at the trunk of the car over here. You're all grouped up together, right?
Correct.
Okay. Now, it was during that first interview and when y'all were leaving the scene, it sounds like Tagler gave you the phone?
She gave it to Mr. Sterns.
Okay. At the entirety of both first interview, second interview, everything. When you're taking the phone to the sheriff's
Oh, sorry. Yes. Yes. Yes.
Gotcha. So you had the phone at this point?
Yes.
Before you had come into possession of the phone to take it back to the sheriff's office, it sounds like it was in Tagler's car?
I'm not sure where it was.
Okay. But between the first interview and the second interview with Mr. Sterns, it sounds like there's about maybe a 4-hour gap, right?
Yes, somewhere around there.
Somewhere around there. And at that point, you said that you went to the management to kind of take a look at the video surveillance, right?
Yes.
Okay. It'll take you 4 hours to go through all the video surveillance?
Not all just at the video surveillance. We were also debriefing, kind of next steps, things like that,
Right.
discussing the case.
So when you're saying debriefing, like, right, just you and Tagler, or are you talking other people?
Other people, the unit,
Okay, so where does that happen?
in the management area.
Okay, so at that point, while you're debriefing, roughly how many law enforcement personnel are there?
I don't recall the number.
Can you remember anybody that was there off the top of your head? Sure.
Detective Tagler, myself, direct supervisors, so maybe a corporal and a sergeant.
Okay, so at least 2 other people present?
Yes.
And it's at this point, so that's where you all were talking to supervisors, right?
Yes.
And at that point, it sounds like one of the supervisors was like, hey, we need to go get that cell phone down, right?
But yeah, I believe it came up during the conversation.
Okay, and then during that conversation, did anybody ever mention, hey, let's get a warrant to download that?
Not to my recollection.
Okay. After you take the phone to the sheriff's office, do you ever interact with the phone again?
No.
Okay, so you just hand it off to the forensics guys and you're done?
Yes.
Okay. And did you ever ask Mr. Sterns if he could download the entirety of his phone?
I did. That conversation was had with Ms. Detective Tagler.
And did you ever seek a warrant to download the phone?
I did not.
Did you ever attempt to draft a warrant of anything?
I did not.
Brief on Mr. Cooper? Between the first interview and the second interview, you had neither you nor Tagler ever gave the phone back to Mr. Sterns, right?
Correct.
You held on to it the entire time?
Yes.
No further questions.
Did you conduct any interviews between the first and second interview with Mr. Sterns?
Yes.
Who else did you interview
Jennifer.
during that 4-hour period?
Yes.
No further questions.
Detective, between the first and second interview, around a 4-hour, at the conclusion of the first interview, did you observe anyone direct Mr. Sterns that he could not meet?
No.
And when you returned after 4 hours, Mr. Sterns was where?
He was in the same parking lot area.
Any follow-up questions, Dave?
No, yeah.
Follow-up questions, defense?
During that time span between the 2 interviews, did anybody?
I don't recall that.
Thanks. May the detective step down?
Yes.
Is he excused from this appeal? Thank you, detective.
Thank you.
Additional witnesses are up.
Yes, Your Honor. Sergeant Darko Staminate?
Please raise your right hand for this morning.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Will you please say your first and last name and spell both for the record?
Darko-Stamenic, Darko-Stamenic.
How are you employed?
I'm currently a sergeant at the Orange County Sheriff's Office Digital Forensics Squad
How long have you been a member of the forensic squad?
since June of 2023.
What type of training have you undergone to perform some of your duties in the forensic team?
So going back to college at the University of Central Florida, I minored in IT. After that, I went to Cellbrite School, where I became a Cellbrite certified operator as well as Cellbrite certified physical analyst. Those are two certifications that we have to use some of the tools that we use. And then I also went to the International Association of Computer Investigative Specialists, where I obtained my certified computer as well.
Did you download any phones as part of the investigation into the disappearance of Madeline Soto?
Yes, I did.
Did you first download a phone that belonged to Madeline Soto?
Yes.
When did you begin that cell phone download?
It was shortly after 2 p.m. on February 27th.
Do you recall about what time that download was complete?
Around 5 o'clock in the afternoon.
That's a couple hours.
A couple hours, right?
Okay. So, can you explain how an extraction is done with the equipment that you used in this particular case?
Yes, so we have a tool that we use to extract the data. So we connect the phone to a tool. The tool's able to extract the data, bypass any whatever passwords there are on the phone, if there are any. Extract the data from the phone. Then we take that data, and we have another tool that parses that data, basically makes it readable by a human.
Is the time that it takes to extract the data from a phone variable upon the specific phone and maybe the data that's included in the phone?
Yes, absolutely.
Specifically with Madeline Soto's phone download, after it was completed, did you have the ability to share the data with other law enforcement officials that were working that same investigation?
Yes, I did.
How did you do that?
So we have a tool where we're able to upload that data that we extracted, and we're able to share it in the cloud to detectives, so detectives out in the field can view it.
Did you do that with Madeline Soto's cell phone the same day that
Yes.
you covered the data?
Yes, I did. I'm sorry.
Did you also complete the cell phone download for the defendant, Mr. Sterns' phone in this case?
Yes, I did.
Do you recall when you received Mr. Sterns' cell phone?
Yes, so shortly before 3 a.m. on February 28th.
Did you wait at Orange County Sheriff's Office Central Communications Building?
I did, yes.
So you waited for Detective Acosta to come from Kissimmee?
Correct.
What did you do upon receipt of the phone?
I began extracting the phone, and then I went home.
Started at about 2:28 at 3 a.m.
Yes.
So what specifically did you do with the phone to begin the extraction?
Connect it to a tool and follow the procedures on the tool to begin the extracting the data.
Was the cell phone itself secured in any way prior to your receipt of it to secure the data in the phone?
Yes, it was placed in airplane mode.
And after you plugged the phone into the equipment that you utilized, you said you went home.
Correct.
Did the cell phone download process during your period of absence?
Yes.
Did you secure the room that this was being completed?
Yes.
And what time did you arrive back?
I believe it was about 8 a.m.
Did you check on the progress of the phone download when you arrived back?
Yes. It was.
God, can you imagine when he walked in? That's the first thing he saw. what was on that phone. Jeez.
How do you factory reset it?
Yes, so you have to go into the settings of the phone. I believe this, the next button says general settings, so you have to go into there. Once you go into there, you have to scroll to a button that says factory reset. Once you press the factory reset button, it asks you a couple of times if you're sure. It makes you type in your PIN code to the phone again to verify that it's you to reset the password, to reset the phone, I'm sorry.
So it's multiple steps to actually accomplish a factory reset.
It is, yes.
Is this possible to do if you're simply updating the operating system on that particular phone?
No, the button to update is in a completely different part of the settings.
When this specific phone is factory reset and the user goes back on to, again, utilize the phone, is there any information that is populated on the phone from prior uses?
Yes, so when you're resetting the phone, it asks you to log back into your Google account, and then information that you have backed up on Google will repopulate onto the phone.
If the phone is placed in airplane mode, does that prohibit the phone from resyncing with a Google account?
Yes, it does.
If items are subsequently deleted from a Google account and the phone is in airplane mode, do the items remain on the phone if they've been backed up?
They do.
If a phone is factory reset, is it still possible to obtain location data and other information from before the factory reset?
It is, yes.
How do you do that?
Different ways. So, for example, the pictures, if pictures are backed up, if the pictures are pulled again, the pictures may have location data associated with them. So things of that sort.
Thank you. Cross-examination.
Good afternoon.
So, you're in charge of doing the forensic downloads of the phone?
Correct.
Okay. And when you're doing those forensic downloads, you said that there's a tool that you plug the phone into to fully download the phone, right?
Correct.
So it's not just downloading the information that's immediately accessible to the user, it's downloading everything, right?
Correct.
When it's doing that download, does it do a bit-by-bit copy of the entirety of that drive?
No, it depends on the phone.
Okay. And with this particular phone, did it?
This particular phone, it did a full file system extraction, so it's not a bit-by-bit copy.
Gotcha. So when it does that, though, if the phone's factory reset, you can still pull that information off the phone, even though it's not immediately accessible to the user?
Like, I'm sorry, what information?
The information prior to the factory reset.
Oh, no, not necessarily, no.
Okay, not necessarily, but in this case, you were able to pull information prior to the factory reset, right?
Yes.
Okay.
Yes.
And when it comes to pulling that information, how long can that information stick around on the phone?
So in this case, the information had repopulated after the reset. So it was on the cloud, and then it repopulated on the phone automatically after the reset.
Okay. Do you know at what time it repopulated?
It was, I believe, around 2 a.m. After the reset. I believe the reset was around midnight, and over the next couple of hours, the phone repopulated.
When you're saying 2 a.m., same day that you downloaded it or before?
No, it would have been when the phone was reset, and I don't want to speculate on the date.
Gotcha, no problem. And when it comes to a phone being factory reset, are you on any kind of timeline to make sure to recover data?
Not really, no.
Okay, so that's not a concern to law enforcement, right?
No.
Okay, so once it's factory reset, doesn't matter.
Right.
Of course.
You have to download this phone. Anybody give you a warrant alongside the phone?
No.
No, of course. Redirect?
Witness, step down.
Yes, sir.
Sergeant Stanek, excuse me.
Your Honor.
We're going to take a 5-minute recess.
This court is in a 5-minute recess.
All right, so they're having a 5-minute recess. Let's see how far behind. Ooh, we're 7 minutes behind, so we're just going to catch right on up. Just like that. Oh, hold on a minute.
Not great. I fake it. I fake it. Next time I might give you like a little. Yes. I wasn't prepared to do something since they were like giving me a call, giving me a. It's okay.
Camera person, I was listening to that conversation. Zoom on back. I don't give a rat's fat kneecap about Stephan Sterns' shaved head. Come on. We were trying to hear that. Actually, I think they will, Pointer Lover, as long as there's, not any like threats. I don't know what they were laughing at, and now we'll never know because the cameraman panned away, or the camera person, I should say. I don't appreciate that camera person. I'm deducting 12 points for zooming at the wrong time. Oh, SJ Sheila, that's interesting. Neat noodle. Probably talking about his gross persona, grooming habits, as I heard he was refusing showers. Huh. Interesting. I noticed that his attorneys actually talk more to each other than they are talking to him, really. I don't know, Emily. Maybe she was trying to teach us the hokey pokey, but we'll never know now because the camera person. Sheesh. Makes me so mad. Just while we're waiting, could you please do me a favor and be like Reebok here and run on over to that like button? I'd appreciate it. Here we go. All right. That's the name of our new little mascot. You know what? That's a good question, Emily. Where is Cement Shoes? If I see him in other chats, I'm gonna be like, bruh, where you been at? We miss you over at the ward. Come back. Oh my God, Kelly. Good for you, Kelly. You feel better? Just a little? Sometimes sometimes putting your feelings to paper is cathartic. I hope it helped you a little bit. Put that last comment. He hasn't? Really, Emily? Well, I hope everything's okay. I do like reporting live from my sofa. He does make me laugh a lot. Do it, Kelly, please. I'd love to see it. I shall keep it confidential, though.
Please come to order. Circuit Court is back in session. The Honorable Pete Carson presiding. Thank you. Mr. Knight?
Your Honor, let's seek some clarification from the court as to whether we're going through all three motions today or just the first two that we're going over, because the state's position is that the burden is substantially different for the challenge to the warrant.
Understood. Do you believe that you have presented the witnesses for the first two motions?
If the first two motions are the seizure motion and the consensual search motion, yes.
Thank you. Defense, in your motion as to the motion to suppress evidence obtained from the Google search warrant, there was some argument that the defense does not have the burden or has satisfied its burden. I'll entertain argument as to that. Sure.
Oh, hold on, Kelly. I will be happy to give it to you. Nightbot should be dropping it momentarily. Hey, Brandy, good to see you.
When it comes to the burden for attacking the warrant itself,
Oh, I didn't press enter. I was like, why is it coming up?
is on four corners. So when it comes to the burden itself, we would be arguing that it's satisfied at least for the arguments we heard at this point, considering that we're challenging the actual document itself.
Understood. So, did you anticipate presenting witnesses or evidence in support of that motion?
No.
Okay. So you're just going to present argument.
Yes. Based on, right now we have the chain of how the warrant came about, and then getting to the cell phone downloaded, and then there's the warrant itself.
Okay. So you're going to make argument as to the sufficiency of the warrant itself and technical defects?
Yes.
And rely on the evidence that's been adduced in cross-examination to support the probable cause, or the lack of probable cause for the...
Exactly.
Does that give the state any clarity?
No, Your Honor, Florida Rule of Criminal Procedure 3.190, subsection G3 specifically states if the court hears the motion on its merits, the defense shall present evidence supporting the defendant's position, and the state may offer rebuttal evidence that the defense's burden is to show that there's grounds for suppression of
So as to sufficiency of the warrant, what evidence does the court have to make some determinations as to the sufficiency of the warrant? Talking about the technical defects that are alleged in the motion.
Yes, Your Honor. At this point, it's actually part of the court file, so we could ask them not to take judicial notice of the search warrant.
It's not part of the court file. Search warrants are not part of the court file.
Absent some affirmative presentation of evidence regarding the argument, there is some kind of technical deficiency that makes the search warrant of the Google activity unlawful. It's going to be hard for us to make a determination as to that. Let me ask the state. Are you requiring the defense to recall the witnesses that have just testified, or if they can find their argument to information that was elicited either in direct on cross, does that satisfy their burden, or shall we go through that entire exercise again? Sure.
Your Honor, the state is of the position that the defense's burden regarding challenging the search warrant has not been met. The state's not going to require the defense to recall the witnesses that have previously testified. However, there is no information before the court about the Google search warrant at this point. So the state's position is that they have not met their burden pursuant to the Court of Rules of Criminal Procedure to shift, to require the state to present rebuttal evidence at this point.
Additional testimony, the court's going to rely on the testimony that's been provided. There was a cross-examination and a redirect. That information is in the record. The defense can make argument that satisfies their burden or not. Is the state anticipating presenting additional evidence?
The state has an additional witness should the court find that the defense has met their burden to challenge the warrant.
Defense makes argument that the Google warrant relied on illegally obtained evidence and that there was no attenuation or intervening circumstances that urged the taker. There's her testimony from the investigating detectives that challenges the legality of both the search and seizure. That appears to be what the challenge on the warrant refers to, and that it is invalid as fruit of those illegal searches. As far as the application failing to establish probable cause, the court does not have the application. As far as the legal standard, probable cause in digital search warrants, the court is uncertain what kind of warrant this was or whether it was a digital search warrant. The that it fails to establish the sufficient nexus between the Google account and criminal activity. I don't have the affidavit, so that would be a difficult finding for the court to make. The reliance on boilerplate language, again, we have no evidence to support that argument. The temporal scope of the court would have no evidence to support that argument, and peculiarity for digital searches. Without additional information, the court would find that there's no evidence to support that argument. As to the evidence supporting the arguments that the search warrant is invalid based on lack of probable cause, based on reliance on illegally obtained evidence of intervening circumstances purging that taint, and being invalid as proof of an illegal search and seizure. I think that evidence has been reduced in combination with the first two motions. So as to those issues, the court will find that there's been record evidence that supports that argument.
Given the hour at this point, the defense would be asking if we can bifurcate the first two motions from the third.
These three motions were set together, and we're going to address all three.
Given the court's ruling, the state will call its next witness, Detective Taylor Heller.
I'm not exactly sure, Allie. It doesn't appear to be going the state's way. I'm not sure. They're calling another witness. And I can't hear any better than you, babe. I'm sorry.
Please raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Right this way.
Oh, now you want to zoom in on the court reporter.
Please say your first and last name for the record.
Taylor Heller.
Can you spell both for the record?
First name is Taylor. Last name is Heller.
How are you employed?
With the Orange County Sheriff's Office as a deputy.
Were you employed with the Orange County Sheriff's Office on February 28th of 2024?
Yes.
Can I approach a witness with both the Mark State C for identification? Sure. Can you take a look at State C? Did you draft the affidavit for search warrant encompassed in State C in relation to the Madeline Soto investigation?
Yes.
Is this State C a fair and accurate copy of that affidavit?
Yes.
Your Honor, at this time, the State C is introducing evidence with the Mark State C into evidence is the state's next number to exhibit.
No objection.
No further questions.
Thank you. Cross-examination. Thank you. Will Detective Heller step down?
Yes, Your Honor.
Is she excused from us?
Thank you.
Additional witnesses or evidence?
No, Your Honor.
Witnesses or evidence defense? take a 5-minute recess. Each side will have 20 minutes to present their argument. I'll ask that you compartmentalize into the individual motions. Take a brief recess.
Oh, for Pete's sake. Some stuff out of my way. I'm hitting the Twitter. Let me look and see. Hold on a minute, you guys. I'm looking. All right.
Please come to order. Serving for the side discussion. Now we'll keep Parsons to the back.
Brandy, the point of this hearing is it's a suppression hearing. The defense is arguing that, hold on a second. So the defense is arguing basically that everything that, all of the evidence that was found on Stephan Sterns' phone, this is for the CSAM charges. All of that evidence needs to be thrown out because Stephan Sterns, while he gave consent to search some parts of his phone, it was limited. They overreached. They searched more than he actually gave consent for. He hadn't slept. He wasn't making an informed consent, and they want it thrown out. So that is the point of this hearing.
This time, defense is moving to suppress the evidence obtained by way of the Google extraction and the entirety of the data that was elicited from Google that was sought by a warrant defense is also seeking to suppress the actual cell phone itself and the data contained therein. For the first two arguments as to the unlawful search and seizure of the cell phone, defendant is relying on the United States Constitution, Fourth Amendment, as well as the Florida Constitution, Article 1, Section 12, specifically that as we go through this is all kind of intermixed between the three motions, but looking to the first motion as to the seizure of the cell phone, at this point, now that the burden has shifted, the state bears the burden to prove an exception to the warrant requirement in order to seize the personal property of Stephan Sterns. As to the seizure, defense would argue that no consent was either sought nor given for the seizure of the cell phone, as well as the fact that there is no exigent circumstances that would create this being a constitutional seizure. As to Detective Tagler, the exact evidence that was elicited was that the detective had informed Mr. Sterns unilaterally that she was going to hold on to a cell phone. This was a declarative statement, not a request, and there was no opportunity to refuse the turning over of the cell phone at that point. Detective Tagler had the cell phone in hand, was clearly exercising dominion and control over the cell phone, and told the defendant straight up that it didn't matter that he wanted to get in touch with his parents or to continue getting in touch with his parents as the night went on, and simply dismissed Mr. Sterns' concerns and unilaterally seized the phone. The seizure of the phone itself occurred at approximately 8 o'clock at night. I believe it was 1959 hours on February 27th. And as of the morning of February 28th, the phone was still in law enforcement's possession. As it was taken to digital forensics at the Orange County Sheriff's Office, the phone was still in law enforcement possession, which we start getting to a point where we're looking at several hours worth of seizure. The state, or the defense, in its motion to suppress based on the unlawful seizure of the cell phone, had cited to United States v. Place, where the seizure of personal property in that case was found to be unreasonable for a time span when this personal property was held for 90 minutes. We're well beyond 90 minutes at this point, and there was no attempt to minimize the intrusion of the seizure of the cell phone. Looking to the state's response, I understand that the state is going to be arguing exigent circumstances, but there was critical testimony elicited from the digital forensics examination witness who stated that once a factory reset occurred, to law enforcement, there was no hope of getting anything after that. During the first interview before the cell phone was seized, law enforcement knew that the cell phone had been factory reset. They dug through his cell phone and they confirmed that it was factory reset. At that point, no exigent circumstance existed as to imminent destruction of evidence, because at this point, essentially, Your Honor, it was destroyed in law enforcement's eyes. The gentleman testified the fact that there's no time span or immediacy when it comes to learning that the evidence could have potentially been destroyed when it comes to a factory reset. Additionally, the timeline itself of law enforcement's involvement in this case entirely negates the urgency element for the imminent destruction of evidence. From the time that the missing report came in to the time of the seizure of the cell phone itself, it was approximately 20 hours had elapsed. There was no immediate action taken to collect this cell phone, and this lack of immediacy completely contradicts the claimed imminent threat by the state. Additionally, when it comes to the seizure of the phone, there was no warrant ever sought. There's no warrant that was presented. This was, again, unilateral action, even though there's been an emergency judge ready to go on duty since the 80s in the 9th Judicial Circuit, both for Orange and Osceola counties, for law enforcement to seek a warrant, and yet they chose not to. When it comes to any other potential claimed exceptions, such as the emergency aid exception, it was clear from the detectives that looking through the phone, the seizure of the phone, this was in order to further investigatory purposes. This was not a situation where they were seeking to render any emergency aid. The community caretaking exception to the warrant requirement absolutely doesn't come into play. The phone posed no danger. There was no community protection purpose. This was purely an investigative seizure. As to the attenuation for this warrant, or for the seizure, there is no attenuation from the moment that Detective Tagler took possession of that phone, handed it off to Detective Acosta, and then handed it off to the Osceola, or the Orange County Sheriff's Office, I apologize. There were no intervening circumstances, and this was one continuous chain of possession by law enforcement. So, essentially the seizure, Your Honor, there's no warrant that's been sought, there's no exigent circumstance that allows law enforcement to collect this beyond the mere claim that they could just unilaterally take it. So for the seizure itself, we would argue that that's for it.
State, would you like to reply on a motion by motion basis? That'd be helpful.
In the meantime, I know the defense cited some of the case law from their motion. I did have the opportunity to review most of the case law. There is one case that I had difficulty finding, so if the defense has a correct site or a copy of the case, I would appreciate it. I could not find appellate per state. The site that you cite, I could not locate. It's on page 7 of your seizure motion. As far as the defense's argument, the defense relies on place, and place is actually distinguishable. Your Honor, I did provide a court exhibit A. I also have a flash drive. I prepared all of the state's case law from the motion, and I put it on a USB organized by motion so that it was easy to be accessible rather than providing a bunch of paper copies. The state's relying on all the case law presented in the motion, and I made it a court exhibit so that it's in the record for appellate purposes. The first thing that we need to do, Your Honor, is decide whether or not, or what type of seizure this was. I would agree with defense that this was a warrantless seizure of the defendant's cell phone. A warrantless seizure of the defendant's cell phone is permissible when you have probable cause plus a warrant exception. In this case, the state's relying on exigent circumstances. The probable cause, there's numerous case law that defines probable cause. The court's well aware of the case law defining probable cause and what it is. Exigent circumstances, there's also a lot of case law regarding exigent circumstances. The specific cases that the state is relying on are U.S. v. Babcock, State v. Darter. The state has to show for exigent circumstances. The test that's used is an objective one. The factual inquiry is the totality of the circumstances. The exigent circumstance that the state is relying on in this particular case is the destruction of the evidence. Courts have found this exception particularly compelling when you're dealing with digital evidence, and that can be found in the Babcock case. We have detectives who are on scene with the defendant, and at the time that the defendant's cell phone is seized, which is approximately 8 p.m., they had the opportunity to view some of the items in his cell phone. They also knew that Madeline Soto did not report to school. Madeline Soto has been missing for over 24 hours. The defendant was the last individual to have seen Madeline Soto alive or seen her in person. The defendant attempted to destroy evidence already by factory resetting his phone. He did this on the same day as Madeline's disappearance. That's evidenced by the history that is in his phone that he consented to looking at. The sergeant from the forensics unit testified what it takes to go ahead and factory reset the phone, but he also indicated that when a phone logs into the Google account and the backup starts repopulating, which is what happened in this case, that content will stay on the phone as long as the phone is not syncing with the Google Cloud account. There's evidence and testimony that upon the seizure of the phone, law enforcement officers placed the phone in airplane mode to prevent that syncing. Should the defendant have accessed his Google account and removed multiple items from the Google account, it would not have removed it from that particular cell phone because that cell phone was in airplane mode and was no longer syncing with the Google account.
How did it sync? How did it repopulate it? Stop syncing.
When the phone was factory reset and that information corresponding with that Google Cloud account was input upon the starting up of the phone, everything that was backed up on the Google account from that phone began populating on the phone. And that's the 2 a.m. population that Sergeant Stamanik mentioned that occurred the early morning hours of February 27th. So prior to these interviews, all of those photos and everything else began to populate on that phone that was in his backup. So when law enforcement saw that there were various items missing and the defendant had already tried to destroy the evidence, it was at that point that they seized the phone, placed it in airplane mode to prevent further destruction. Testimony. Though the defendant factory reset the phone, there was still a possibility through different avenues to ascertain that cell phone's location information and different things. So at that point in time, there was a fear that was objectively reasonable to a reasonable law enforcement officer that would lead that officer to believe that the evidence might be destroyed before a warrant could be secured. That is the standard. Probable cause plus exigency. Everything that was known to these law enforcement officers prior to this seizure supports the probable cause finding as well as the exigency finding. They also were aware that the defendant was inconsistent in his statements to law enforcement about where his whereabouts were on February 26th, the day that Madeline Soto went missing, because his initial statements were contradicted by the actual tag reader for his vehicle. His vehicle was seen traveling in the opposite direction of Madeline Soto's school when he indicated that he was driving towards the school and going to McDonald's and dropping her off. There were other inconsistencies that are within those statements that he made, specifically the ones that were provided to the court and are entered into exhibits in this particular hearing. There are multiple inconsistencies. All of these things lead to probable cause and exigent circumstances for the seizure of that phone. Therefore, the seizure was permitted by the Fourth Amendment in this case, regardless of whether the defendant said, yeah, go ahead and take my phone. The law enforcement officers had the ability to do that. The defense also mentioned place. That case is distinguishable because in that initial detention, that 90-minute detention that they're talking about in there was based upon reasonable suspicion alone. That court then later says that once that dog sniff was done on the luggage and they developed probable cause, that's where they get the 90 minutes from the time that the luggage is detained until they've secured probable cause. That's not the standard here because because the state's relying on the probable cause plus the exigency to support the seizure. So the place case is actually inapplicable to this case as far as the defense's attempt to have the reasoning support their argument.
Thank you. Brief rebuttal, and then let's move on.
Briefly, while the state argues that there's the two-prong analysis as to probable cause and the exigency, again, when it comes to the exigency, the direct testimony that was listed during the hearing is that to law enforcement, there is no exigency at the point that the phone is known to have been factory reset, that there is no imminent destruction of evidence because there's no further destruction of evidence. It's already been destroyed. So while we can speculate and guess as to what Tagler and Acosta, the detectives on scene, were thinking as to seizing the phone, what we know for a fact from the Orange County Sheriff's Office is that they know that once a phone's factory reset, it's gone. There's no more imminent destruction. So for the exigency element, I would argue that has been said. Moving on to the second motion, if your Honor's ready.
Johnson, I'm ready.
Yes, sir. As to the motion to suppress the unlawful search of the cell phone, again, the burden is flipped to the state. They have the burden of proof to show some kind of exception to the warrant to search of this phone. There was no warrant ever obtained for the actual search of the phone, be it the searches done by Detective Tagler on scene, nor the actual cell phone forensic download. Now, as to the first request by Detective Tagler on scene as to the maps, the statements from Detective Tagler was, "Do you mind if I look at your maps real quick?" At that point, the defendant, Mr. Sterns, had indicated, "Yeah, that's fine." When we look to consent, scope of consent is an essential element when looking to the validity of law enforcement's actions. At this point, there was limited consent to look only to the maps application only, not consent to search the entire phone. As to the second request, as to when Detective Tagler asked, "Do you mind if I just take a picture of your history?" and Mr. Sterns replied, "Yeah, that's fine." Again, this was limited only to taking a photograph of what was already visible on screen, not consent to navigate through the rest of the phone, through additional screens, not consent to access other applications. To the third request from Detective Tagler, if I can go into your settings real quick. I just want to see if you're logged onto your Google. Again, at this point, after pressing Mr. Sterns agrees, but again, this is, again, limited consent as to merely looking at the settings screen to determine if he's logged into Google. At no point did any of the detectives or any member of law enforcement seek consent from Mr. Sterns to go through the rest of his cell phone, which then we can see Detective Tagler's overstepping the scope of consent when she later indicates, "I was checking your call history. I noticed that you don't have anything before this morning." But when questioned, and as evidenced in the recordings that Your Honor has, there was never any consent sought or given as to checking the search of the call history in this case. So that is completely outside the scope of the searching of the maps, the history photo, or the Google login check. Additionally, when we're looking to consent as to Detective Tagler's request to do an entire forensic download of the phone, this is where defense relies on the Ramirez factors. When looking to the Ramirez factors, the defense looks to Mr. Sterns' freedom to leave. While the state is going to argue that he was free to leave and the detectives stated that he was free to leave. No statement was ever made to Mr. Sterns that he was able to leave the scene at any time. Instead, what happened is that...
Is that required, or is that a factor to be considered?
It's a factor to be considered. And when considering that factor, we're also looking to what a reasonable person would feel in that situation. So at this point, Mr. Sterns is being corralled by two detectives by a vehicle. He's not allowed to go back inside of his home. He's not allowed to go inside of his own car. When it comes to the apartment complex, there's law enforcement all around. There's law enforcement at the entrance regulating who's coming and going outside of the apartment complex. It's clear that law enforcement essentially has the scene locked down. And not only do they have the scene locked down, while the state asked whether anybody had drawn firearms or anything of that nature, it was clear from everybody that testified that firearms were readily apparent, visible on scene, which would lead to Mr. Sterns feeling that he was not free to leave. When we're looking to any potential course of police procedures, again, we have a situation where Detective Tagler systematically keeps pushing boundaries of searching Mr. Sterns' phone. First, it's just a check for, hey, can I check the application? Then I want to take a picture of the phone. Then we're going to keep pushing into the settings. And then the detectives push more and more to the point where they start checking other parts of his phone without asking him for his consent. So at this point, a reasonable person would believe that, well, law enforcement has my phone in their possession. Law enforcement's going to keep looking through the phone. And while the argument is that he stood there and never said no, it's not the onus. The onus is not on Mr. Sterns to say no. The onus is on law enforcement to ask if they can continue to go through this, because the scope of consent is limited. And while the detectives and the state want to argue that, well, he stood right there and never said no, Your Honor, some 200 years ago, our forefathers said no for him. That said that we have a situation where there's no warrant. Law enforcement has seized his phone. They're searching his phone. The Fourth Amendment says that you cannot do that. The no has already been said for him. When we're looking to the ability to refuse consent, additionally, law enforcement never told him that he could refuse to allow them to look through his phone. As to the education and intelligence, when it comes to law enforcement's testimony, they knew that Mr. Sterns was currently in a state of, or this actually goes more towards physical and mental state, that Mr. Sterns was currently in a distraught, stressed out state. They were aware that he was taking medication to try and fall asleep, to take care of himself during these long hours during the course of this investigation. When we're looking to the actual physical state of Mr. Sterns, we know it's about 50 to 60 degrees outside. We know it's night. We know the sun has gone down. We know law enforcement's with him. We know that he's in flip-flops and khaki pants, and he's not allowed to go back inside his house nor his car. So physical discomfort may have affected his decision-making process. When we look to the standards here again, it's not what law enforcement believes that Mr. Sterns was. It's what would the typical reasonable person have understood what the situation was. And in this case, Your Honor, the defense would argue that as Detective Tagler consistently pushed the bounds, then held onto his phone, just unilaterally seizing it, dismissing his concerns about trying to contact his family, comes back hours later and gives him the Hobson's choice, that ultimatum of, you can either consent or we can get a warrant. At that point, Mr. Sterns' ability to consent has been tainted, it's been coerced, and for that reason we would argue that all of the searches of the phone violate the Fourth and Article 1 section.
Thank you. Ready?
Your Honor, the defense is not arguing that the defendant did not consent to law enforcement looking at his phone. Some of the things that I think are important to point out to the court defendant in this case was free to leave. Both law enforcement officers that were interacting with him were in an open parking lot where he was free to move about. He was in and out of Ms. Soto's vehicle. There was no testimony before, Your Honor, that there was any threats or prohibiting of his movements. The defense argued that Detective Tagler consistently pushed the boundaries. However, Detective Tagler did not push the boundaries of consent in this case. There were multiple things where she was verifying with the defendant his continued consent for her to examine different parts of the phone. The defendant was in possession of his cell phone, unlocked it, and provided it to Detective Tagler. The defendant did not try and retain control over the phone. The defendant did not try and take the phone back from Detective Tagler. The defendant did not try to himself show her various portions of the phone. There was no attempt by the defendant to limit the consent in any way. The scope of the consent is measured by objective reasonableness. What would a reasonable person have understood to be the object of the search during the exchange between that person and law enforcement? You have Detective Tagler, after speaking with the defendant and him being inconsistent about timings and locations, she asks him, do you mind if I look at your maps real quick? The defendant confirms. It's at this point he unlocks his phone and hands it to Detective Tagler. Detective Tagler does not walk away with the defendant's phone. They are standing shoulder to shoulder. The defendant can see everything that Detective Tagler's doing. Detective Tagler then says, do you mind if I just take a picture of your history? To which the defendant responds, that's fine. There is no attempt to limit the type of history that Detective Tagler is going to look into. There is, this conversation happens, the detective is looking at the defendant's phone. Subsequently, the detective looks at the defendant's call history. And there's actually a conversation with the defendant about how Detective Tagler doesn't know how to use the defendant's specific phone. She also asked to go in the settings, and in the audio recording, there is actually a substantial pause before she's finds where the settings are. She actually says, I don't know how to use this phone. Sorry, I didn't mean to interrupt, as he's having a conversation with Detective Acosta as well. There is no time during that encounter that the defendant attempts to withdraw his consent or limit his consent in any way. The defendant does receive the cell phone back from Detective Tagler. There is a portion in the interview where she does say, here you go, to which the defendant responds, thanks. It's a little bit further away from the microphone, so it's a little bit harder to hear, but that conversation does take place before she asks the defendant a second time to unlock the phone. So the defendant does regain possession of the phone. Then she asks to unlock the phone a second time after she steps away. The defendant does so. Again, does not limit the consent in any way. There's actually no conversation at that point about what is going to be looked at. And then she brings up the fact that his call history is not there.
Is this information that she had prior to giving the phone back, correct?
She says, I was checking your call history. I am unclear at what point she looked at it. I believe it's around this encounter. but it could have been before. My position, the state's position is it's during this time frame where she's asking.
The argument of the state was that she asked to take a picture of the history, looks at the call history.
She takes because it's what a reasonable person would understand the interaction is going to be. My position is that she uses general term history, and then she eventually goes into the call history.
Is that in the first time she's got possession?
That's in the first time that she has possession of the phone. Yes.
At what point in that sequence is the exigency argument, is the state's position that the detective becomes aware of an exigency of the destruction?
It's the second time he hands her the phone. Because she asks him to unlock the phone. They have a conversation. She brings up that the call log. She said, I also noticed, I was checking your call history. I noticed that you didn't have anything before this morning. Is that unusual on your phone?
And that's when the discussion about the
Factory
reset occurs.
Yes.
It's the state's position that on that discussion, that provides the basis for the state's exigency circumstance.
Yes, coupled with everything else that law enforcement knew, yes.
Probable cause.
Yes, yes.
Sorry, I didn't mean to misdirect you.
So it's at that point that there's a seizure. There's some other information that's ascertained by law enforcement, and then they do a second interview with Mr. Sterns. The second interview begins at 12:16 a.m. and almost immediately jumps into addressing consent to forensically download the phone. It's not very long after their initial introductions on the audio recording. She says, I told you I was going to hold on to the phone. We would like to download your phone. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? The state's position is the way that that statement is phrased, it is clear to a reasonable person that the defendant had the opportunity to refuse to consent, because either the defendant can consent. If the defendant does not consent, law enforcement ultimately would seek a search warrant. The defense wants to call that an ultimatum. The state's position is that it is advising the defendant very clearly that he has the ability to object or not allow consent for the forensic download. There's no question that law enforcement was seeking a complete download and to go through the entirety of the phone by the way that that conversation is had. Because he ultimately answers that question affirmatively, and then she follows up, you're okay with us going through your phone? To which the defendant responds yes, and then he ultimately provides his passcode to the cell phone. Based upon all of the totality of the circumstances and all of the information that law enforcement had and the lack of coercion by law enforcement towards it. In fact, the defendant was actually free to leave and did leave the apartment complex after this second interview. He wasn't allowed to leave in his vehicle because his vehicle was seized, but he and Jennifer Soto left in Jennifer Soto's vehicle. That goes to any coercive nature argued by the defense. The state also relies on the same factors as permitted by case law. Whether or not the defendant was free to leave, whether there was any coercive police procedure, the extent of the defendant's cooperation or his awareness of the right to refuse, whether the defendant could have refused, defendant's education and intelligence, and the defendant's...
I think as fast as I type, so I was with you up to extent of cooperation.
Or his awareness of his right to refuse, whether the defendant could have refused consent, the defendant's education and intelligence, and the defendant's belief that no incriminating evidence would be found. All of these factors should be considered by the court in determining the defendant's voluntariness of consent. So the state has to show that the consent was voluntary by clear and convincing evidence, and the consent has to be freely and voluntarily given. That is the standard. There was some case law that distinguishes it from a formal waiver of Miranda and things like that, other constitutional rights. The standard for consent is whether it was freely and voluntarily. So these factors that we just discussed go to the voluntariness of consent. So for the consent that occurs on February 27th, so that first interview where they're actually looking through the phone, the state's position is that consent was valid. The defendant unlocked his phone twice and handed it to Detective Tagler twice. The defendant specifically consented to map data viewing and documenting his history, reviewing settings to see if he's logged into his Google account. The defendant was standing directly next to Detective Tagler as she was viewing the content. There was not the word history was used in the state's position in a general way. It wasn't a limiting way. And at no point did the defendant intend or verbally or physically or any other way communicate that he was limiting or withdrawing consent. He was free to leave during the conversation. He was not in handcuffs. There was no police coercive tactics. The state's position is the defendant was aware, based upon the questioning, that he had the right to refuse. He could have not unlocked his cell phone. He could have said no. There was a lot of testimony that he was free to leave and he could not have consented. They're not in a confined space. And the biggest one is the defendant thought he destroyed all of the evidence. The defendant factory reset his phone twice on the date of Madeline Soto's disappearance. And the reason why he consented is he believed that everything was gone. So the state's position is that the consensual searches that were conducted in this case were valid and permissible under the Fourth Amendment.
Thank you. Brief rebuttal.
As to the state's argument that looking to Mr. Sterns' belief that he was free to leave, again, this isn't on law enforcement's observations. It's based on what a reasonable person would believe in that situation. Here, while we don't have
Detective Tagler twice. The defendant specifically consented to map data viewing and documenting his history, reviewing settings to see if he's logged into his Google account. The defendant was standing directly next to Detective Tagler as she was viewing the content. There was not the word history was used in the state's position in a general way. It wasn't a limiting way. And at no point did the defendant intend or verbally or physically or any other way communicate that he was limiting or withdrawing consent. He was free to leave during the conversation. He was not in handcuffs. There was no police coercive tactics. The state's position is the defendant was aware, based upon the questioning, that he had the right to refuse. He could have not unlocked his cell phone. He could have said no. There was a lot of testimony that he was free to leave and he could not have consented. They're not in a confined space. And the biggest one is the defendant thought he destroyed all of the evidence. The defendant factory reset his phone twice on the date of Madeline Soto's disappearance. And the reason why he consented is he believed that everything was gone. So the state's position is that the consensual searches that were conducted in this case were valid and permissible under the Fourth Amendment.
Thank you.
As to the state's argument that looking to Mr. Sterns' belief that he was free to leave, again, this isn't on law enforcement's observations. It's based on what a reasonable person would believe in that situation. Here, while we don't have
Oh, what the heck? Are you kidding me? Hold on. Let me see what happened. They just absolutely cut it. What in the actual F? Hold on. Let me see if they like figure out what they did. Oh my gosh.
We'll be right back.
Hold on. Don't go anywhere, you guys, because I don't know what they're doing, and I'm hoping they will fix it. Well, here's a look at the traffic. Oh my God. You have to be absolutely kidding me. Hold on. Let me see if another, if somewhere else is, there's another pool for this. Give me a second, you guys. Give me a second. Let me see. This is so annoying. I'm so sorry, you guys. Let's see. Hold on. Give me a second. I found another feed and it cut off too. Hold on. Give me just a second. Give me a second. I'm just going to listen and see if they get the feedback, because this makes me so mad. Like, who was in charge of this? Big trouble, big trouble. No me gusta. See if we can get it back. Hold on. Give me a second, you guys. This is so annoying. Yeah, they're not going to be able to, it's not coming back. What a load of poop. Look, all I can tell you is this. If they're going to, if it's going to be local who carries this, they need to make sure they stay the whole time. We can't be doing this business where all of the sudden they just decide. Hold on, let me go back to the original channel I was watching it on. Let's see if they come bring it back. This is very annoying. I don't appreciate this. Hold on. I guess they interrupted the feed because they wanted to go live about a brush fire in Palm Bay, which I'm not judging. That is important news, but so was this. And this is very irritating. And I don't think they're going to be bringing it back. Oh, that makes me so mad. Unless they switch. Let's see if they do. Apparently they're having issues because even this feed is messed up. Yeah, that feed's messed up too. Good Lord. What's happening here? Very disappointing. Mm-mm-mm. All right, you guys. Well, I guess that's it. No, it's not. The judge didn't do anything. What happened is it's a pool feed. And so usually when that happens, it's one local channel that covers it, like a news channel. In this case, it was News 6 Click Orlando. They were in charge of streaming it. And for whatever reason, the feed was cut to go to hold on a minute. The feed was cut and they went to this Bruh, come on. And they went to this brush fire for some reason. Don't know why. They just did. And there isn't anything that I can do to get it back. I mean, if I go to their channel, I can still. What says denied? That their motion was denied? I'm going to wait for, let me look on Twitter. Let me see if I can find something for you guys, because I need to know. We need resolution. Wait a minute. On the, okay, let me just look at X. Give me a second, you guys. All right. Can you, can you send me the docket link, Allie, and I'll check it, please? Let me refresh this and see if it comes back. Give me just a sec. Huh. Yeah, this is a problem. Well, I'm not sure where you're looking, Lily, that says it's denied. If you can tell me where you're looking, babe, then I can try to find it, because there was a motion that was denied by Stephan Sterns, yes, for Stephan Sterns attorneys yesterday, which was that they wanted a continuance for today's hearing, but that was denied. The other thing that was denied was he didn't want cameras in the courtroom. That was also denied. And even if I look at his docket, that's likely not going to be helpful, because that's all right, Lily, you're fine. Likely what's going to happen, I don't know if I'll try to look at the docket. I mean, I can look at the docket. I don't need to try, but I feel like looking at the docket is not going to be helpful, because if the judge, it's likely not uploaded yet to the docket, because they were still in the middle of hearing. We were only 2 minutes behind in the stream when it ended like that. And so, I doubt that he's made a ruling yet. However, that being said, that doesn't mean that he won't rule today. He might make a ruling today. He might make a decision today, and that would be potentially uploaded to the docket. And so I can keep checking that. Hold on. Here comes Allie. Hello.
Hey, okay,
Hi.
just 1 second because I have the docket pulled up on the computer for the wrong case. Let me go back.
Okay.
And I couldn't send it. Well, I mean, I can, but I'm logged into Facebook on my other account, which you're not a friend of. So it'd be like I got to go around. Okay, let's see. We have the latest filing is, it says felony court minutes, order hearing held on the following motions. Yeah, there's no written order on it. So yeah, it just says felony court minutes / order hearing held on the following motions. Defendant's motion to suppress evidence obtained from Google search warrant. Defendant's motion to suppress evidence obtained from unlawful searches of cell phone. Motion to suppress obtained from unlawful seizure of cell phone. And the state's response as to each motion. Defendant present with counsel, sworn and testified for the defense. Stephan Sterns for the state. Francis Hutt, Maria Tagler, Luis Acosta, all the people that testified. And then it says Exhibit 1 through 3 entered into evidence, arguments made by both parties. Court reserves ruling on all 3 motions. Court will issue a written ruling, Court Exhibit A, to be held in evidence by the clerk of court for appellate purposes. So that means what? That it'll be on the docket, the written ruling?
It might be. Do you let me look at something.
If you give me, it's Osceola County. If you go to courts.osceolaclerk.com, you can search his name there.
Yeah, let me look. I got it right here.
And it's not the one that ends in 9-3. That's the
That's the essay one or the murder one.
yes. Yeah.
Oops.
So
Lord have mercy, Jen. Can you learn to type today?
Kristen said everyone on YouTube is on the Osceola County website right now, and that's true. Yes, thank you for trying, Bendy. Like Emily says, I mean, it's hard because we're
I
sitting
got
here
it.
watching, and then it's just cut off like that. Like,
all right. So which one is it not? The one that ends in 9-3? That's not the one we want, right? Okay.
Yeah.
All right. Let's look at this. Well, oh, here we go.
See at the top. Like where all the motion, where all
The hearing.
Yeah, where all the different motions, where you'll see like where you can click and get the PDF for each motion at the very top of that. If you
See, I don't have that. Hold on. Hold on. Let me see if I clear. Okay, maybe I can see that now. I just have to let it load. Oh, come on. What the fuck? Okay. He has 3 cases. Well, one is closed. Wonder what this one is, just out of curiosity.
I can't even remember, but yeah, the closed one.
Oh. This was the one from, this is from this year. I don't know why they closed it, but it's sexual battery victim under 12.
I think that might have been the first one, and then once they came in like later with the 60 charges,
Right.
But I don't know.
Okay, so when you go to the case searches, right, you know, it has that little folder thingy. That's where you click.
Yeah. So okay, you click
I
that.
see now. I see now. View case.
Yeah, and then you'll see parties and then charges, and keep going past those long 60 charges. Events.
Yep.
outstanding amount, keep going
Yep.
to
Keep.
case
Oh,
docket.
I
There you go.
see.
And actually, right there, you can click on each and every motion and open and read, like, and download the PDFs. I've downloaded a ton of them for different things because they've filed a ton of interesting stuff. They want, anything about Maddie kept out. They want victim impact statements about how this has affected his family put in. They have some crazy requests, but yeah.
Oh, I need to bookmark this.
Yes. And then if you look, that top one, it's not you can't
Yes.
download a
You
PDF.
can't do
but
anything yet because it's not been uploaded. Okay. So there's not been a ruling. Ah, thank you, Allie, for coming up here.
Oh, you're welcome. I've been listening, but I wasn't in chat the whole time because I was doing, housework and packing and all
Can
that
you do my
stuff.
housework?
I don't know, Jen. I can hardly do mine.
I don't have very much.
Oh my God.
I really
have
just need to
tons.
do laundry. I've got to, this weekend, we're going to the storage and getting everything out of it. We just got a few things last weekend because, my husband was on call. And so, yeah, I agree, Kristen. That station should not be able to carry that and no more.
No, I agree too.
No, absolutely not. No me gusta. We vote no.
The problem is here, even when the housework's done, there's new housework becoming made every second, whether it's the kids
Girl.
or me. Like just now, I was making them a snack, and of course, I dropped blackberries all over the kitchen, and then some rolled under the fridge. So I had to like it was, oh God, it was a struggle,
Bless
but I
your
got
heart.
them.
Yeah, they just freaking abruptly ended it. No, okay. News 6, click Orlando. You're not going to get a good Google review. I'm telling you right now. And I'm going to take my butt to Yelp as well.
Yeah.
You don't want the smoke. I'm a YouTuber.
It is cool though. I didn't realize during each hearing they would put so much in that little description on the docket, like every
Yeah.
witness who testified, all that kind of stuff.
They do a
So,
lot.
Yeah. So, anyway, okay, I'll jump
All
down
right,
and
babe. Well,
I know you've been
okay,
on here forever.
before you go, just let everybody, just to let everybody know, there's more Tisha. There's been a ruling. Allie will be live at 6. Are you at a place where you can put? No, I will do it. Let me do it.
7 Eastern.
7 Eastern. Okay, I'm going to share that right now.
Thank you.
I'm so excited to hear that. Hold on, let me see.
And then I was gonna just ask you, and also Little Red too, again, since she got it, if you guys want it, after I read it, I'll just either message you the link or pin it at the top or something. Maybe I'll pin
Okay.
it just to see if anybody else joins it.
You should.
Just for fun, but
you know how people love an open panel.
Yeah, so the judge has written an order, and but it's not on the entire case, it's just on some of it, but it's not short. And then I grabbed, actually Little Red had sent me something that you and I went over 2 years ago, but it's interesting to look at it now, tying it back into
Speaking of things from 2 years ago, we need to send that email.
Yeah, no doubt. That has definitely been 2 years ago. Yeah, we need to figure that out.
We do definitely need to figure that out. All right. Well, thank you for coming up. Thank you for helping. I will be over there. I don't know if I can come up because tonight's our anniversary. And
I forgot.
Yeah, and but I also promised Chicky Nuggy Papa Esquire that I would have her to come over for dinner.
Okay. Oh my gosh, how fun. That's the best anniversary present ever, though,
It is. It really is. I'm so sorry about the stream letting everybody down, you guys. I'm so sorry.
No, listen, no,
I
it
feel
didn't
bad.
actually. Because here's the thing, though, we got to see and hear more, and
that's
seeing the
true.
detectives, hearing about, it just was nice to be able to put a face to the one detective and hear a little bit more about her experience. It's not a failure. We just don't have an answer.
That's true. We'll get an answer, you guys. We will get an answer. I will be refreshing that. There's a few other things of answers I'm waiting for. Todd Mullis, still waiting for an answer for that. I'm also still waiting to hear the DNA test results from the West Memphis 3. They were expected at the
Oh,
beginning
yeah.
of 2025. Now, I suppose beginning of 2025 is subjectives, considering we're only like into the 4th month. But for me, that's 3 months too long. I wanted to have it on January 1st,
I remember
2025.
you talking about that and looking forward to it. Oh, also, didn't mean to cut you off, but so I don't forget to say this. There's no difference anyway. The footage got cut off for everyone, but the judge didn't decide. It said he was going
That's
to make a
true.
written ruling, so we wouldn't have
That's
known
true.
anyways.
I really, and I think the reason that he's going to make a written ruling is because of purposes of appeal. I think that he is going to rule that it is not going to be suppressed. And I think the reason that he's chosen to make it a written ruling is because he's going to cite case law to support his ruling. Remember when Judge Kranick issued the ruling for Sarah Boone about her having to either represent herself or use a private attorney. And he issued the written ruling because he wanted to go over all of the things that had happened up until then. And he cited a lot of case law in that to support his decision. So,
oh, I hope you're right, Jen.
I
I
think
really
that's
do.
why because it's, it's what a reasonable person would say, would believe. He was not in police custody. He was at a residence. Now, granted, it was not his residence, and I don't really give a rat's fat kneecap whether or not he was dressed for the weather. Homeboy has been living in Florida for 7 years. That evening, into the early morning hours in February, that's typical February weather for that part of Florida. It is not anybody's fault that fool doesn't know how to dress for the weather. That's nobody's fault but Stephan's. Okay. And I would like to remind everybody that it really, listening to the officer's testimony tells you and reminds you, just me too, how fluid an investigation of this type is. They were getting information moment by moment and having to change the direction and, be for the next thing. And when she got her hands on that phone and realized, hey, his call history is weird, because there should have been a lot more call history, number one. Number two, and then she asks him about it, and he says, I accidentally factory reset a phone. Now, maybe if this was her first day on the planet, she would have believed that excuse. But anybody and everybody knows that there are multiple steps to a factory reset. And I'll tell you this, particularly on a Google phone. Google does not trust your decision-making skills, which is why they will repeatedly ask you, are you sure? Are you really sure? Are you really, really sure? Okay. Now, had this been an Apple phone, Apple will give you like 2 chances. Okay. And that's it. An iPhone is like, okay, you said yes. We'll make sure you say yes again. And that's it. That's all. No regrets.
Well, I think that they gave some good arguments as to like why in the other things, like they said that they only need a couple things to not even need his consent, right? And so
Yes.
they had met those marks too. But
Yes.
yeah, I don't know. It's going to be interesting. I can't wait to watch the trial. Yeah, and thank you for having me up, and thank you for streaming this. This has been a
You're
long
so
day for
welcome.
you.
Yeah, but I
Was-
don't mind it. It's good for me. It gives me something to do. It keeps me out of trouble. And I'll have you know that earlier this morning, because I needed to focus on what was coming out of Carrie Roberts' mouth,
Yeah.
instead of being like every time she, would backtrack or whatever, it was irritating to me. And I knew that I was going to be interrupting. So I organized the bathroom.
There you go.
And cleaned up the kitchen, because like I couldn't do it. And
Yeah.
so like this has really been good for me. And I will be back tomorrow morning with Karen Reed. What we'll do is, when they go to lunch tomorrow, we'll watch the stuff that we missed this afternoon. Let's do that.
Oh,
If we
okay.
can, we can watch it on 2 times speed. And
Yeah.
then what I can do is go, if I have to, I can go like a little late tomorrow. So after it ends for the day, we can finish catching up if you guys want to do that. It's up to
You know,
you.
I really like when people do that, and then I'm going to jump down and let you keep talking to your chat and say goodbye.
Okay.
But when I'm watching a trial, I love when they will like start a little bit late, or because I've watched like a few hearings and trials from Emily D. Baker with Idaho,
Mhm.
and she always does them late, and this way she can like skip the breaks and stuff. So, you know, having your own schedule, kind of doing it your own way, even if you do part of it on time, the other part being late, it makes it easier to get through it because you can skip stuff that's unnecessary, you know?
That's
So,
true. That's true. And the only reason to start on time tomorrow and not go through the skips, which is just because we missed the afternoon session. But
yeah.
Friday is only going to be a half day, but Monday is only going to be a half day for the jury, but not for us. You guys we cannot be slacking because there's going to be arguments, you know, and how you know, Judge Bev is going to show that bias. You know, she is, you know, we're going to get outraged. You know, we're going to get irritated. So let's all get irritated and outraged together. What better way?
All right. Well, thank you for having me, and I'll
All
talk
right,
to you
babe.
soon. And
All right.
yeah, I understand if you can't come up, but I always want to offer because I want to hear from you. You've been going
Always.
through it since day one. And with Little Red too, you know, getting us the documents and stuff. And I just
Yes.
appreciate that. So
So
I
much
can't
help.
wait to read through it. But yeah,
So
all
much
right. I'll
help.
talk to you in a little bit.
Thank
And
you, babe.
happy anniversary, and
Oh,
hope you
thank
have
you
the
so
best
much.
night.
Oh, thank you so much. I appreciate that. Bye, babe. I'll see
All
you
right.
over there.
Bye.
I'll be there. I just don't know if I can come up.
Okay. All right. I'll talk to you in a little bit. Bye.
All right. Bye. All right, you guys. So that is that for the Stephan Sterns hearing. I appreciate you guys sticking it out with me. I have to say, I do agree with Rachel in the chat who says, if this had a snowball's chance in hell if the defense had a snowball's chance in hell of having this motion granted, I think she's right. I think Mr. J would have argued this. He is incredibly good at the nuanced arguments and is so good at shutting them down. I think this was they had to try it. I still don't know, and we won't know. We may never know what this confidential information that they need to explore to see what, if any, impact it has on their defense. Who knows? I don't know. It seems like a bunch of, just nothing. It's a whole big nothing burger. But anyway, I want to thank you guys all for being here. If you have not done so, would you please give your girl a thumbs up on the stream? I would appreciate it very much. I will see you guys tomorrow, bright and early, 8 Central, 9 Eastern, for more Massachusetts versus Karen Reed retrial. All right. You guys have a great rest of your night. Thank you so much for the happy anniversary wishes, and I will see y'all in la mañana. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No 2 minutes later.
We all do a little mad sometimes.
And you know this, man.